Oh, am I muted? Yes, sorry, guys. So, guys, oof. Yeah, well, I was trying to catch up to the chat here first. But anyways, hello. Welcome, everybody. Yeah, that was a great way to start it. Yes, so anyway, guys, we're looking at this. This is a case out of Ohio. Now, why does this matter to you? Well, it doesn't. But I practice in Ohio. I live in Ohio. So this is an important one. This is really huge. This might be an argument you can make where you live. Is it going to guarantee that where you live, you may be allowed to do this or persuade a court? Your attorney could? Maybe. Maybe they could. I don't know if that would work that way. And hold on. Gotta close the door so the dogs aren't barking. This may help you down the road. And hopefully, if somebody out there is an attorney watching this in another state, hopefully this gives you a reason to make some case law up or try to work with things that you have in your neck of the woods. 100K Hitman says, do put the chat in front of your face. It's literally right here. But I scrolled all the way up at the top to highlight the who was first. So I can't, it doesn't, there. So just take your titties, get some ice, and ice down your titties. Ice them down. We're going to live. I promise. You are going to pull through this. I promise you, you will pull through. Just believe in your mother and I. I promise you. But this, I think, is very interesting because in Ohio, if you tried to tell me, hey, I'm going to shoot a warning shot, I would tell you that's not a good idea. And I would tell you that courts are not going to allow you to make a decision. They're not going to allow you to argue self-defense, but it looks like that's going to change. Now, I don't think this is permanent. I think this is a very sketchy, rickety decision, and I will explain why I think it is, given who made the opinion and what does it really say about things. So, Castus wants us. Hello from California. Good to see you. Good to see you. Now, we already got 116 people here. Good, we're chugging along here. I need to do an entire stream on mute. Yeah. Well, we're not going to do an entire stream on mute. But Unhung here, we already have for $2, says, oh, I'm going to come. Well, don't come. Don't come. So. Physics gave us the A-bomb and Marie Curie's radiation death. Yes, it did. All right, guys. So, we're going to get started. Lucas says, yes, it's less of a decision about warning shots and what intent is required for a self-defense jury instruction. Yes, but as, when you think about it, what's required for the jury instruction is what your actions dictate and what you can prove and what the arguments you can make. And to be fair, there is no such thing as a warning stab. Like, get back. You're not really going to get charged with anything there. Maybe if you're, like I said, if you're chucking spears at someone, okay, well, maybe you have a warning shot. But generally speaking, this is going to be more of a firearms-related issue about warning shots. And that action allows the jury to then determine, your intent. Because then they get an instruction that allows for it. So we'll get to it. We'll get to exactly what's going on here. So it all starts, it starts with this guy. And the guy I'm going to show you is a guy named Tyler Wilson. Boogie's not moving to Ohio. Oh my God, I would chase him out of here. But we start off with looking at a guy named Tyler Wilson. Okay? So this is Tyler Wilson. His admission date was November 2021. And this is him. And he was charged with felonious assault. And from there, we go back, okay, and say, well, gee, what happened to him? Well, he's in prison. And how long is he doing? he is doing 3 years plus 5 years plus another 8 years minimum. Now, this 8 to 12 is called indefinite sentencing in Ohio, meaning his initial sentence is 8 years. If he's compliant and a good boy in prison, they will release him. If he's a bad guy in prison and causes a lot of problems, gets arrested, doesn't do what he's told, they can hold him for up to another 4 years under state law. But a minimum sentence he has to serve is going to be 16 years. 8 of them are mandatory. The other 8, well, he could possibly be released or subject to parole at any time. So he's looking at a lot of time right now, guys. You know, his expected release date is 16 years. So July of 2037. So he's got a lot of time on his hands. A lot of time. Yes, fair St. Patty's Day to you. Yes, happy St. Patrick's Day. So what happens from here? What happened to him? How did he go? How did he get to this point? Well, that's where we get to the case. So this is from the Ohio Supreme Court of Ohio. And this is just come out. It's brand spanking new, guys. And it is known, and you can tell it's new. I mean, well, it's 2024. And that's how the case, in Ohio, this is how they do the cases. The new way of reporting cases, they use the date, they use the year to start it off. So for them, it's 2024, and it's a 776 case. And it's cited as State v. Wilson. And it was submitted from Clark County. If you guys don't know where Clark County is, it's Springfield, Ohio. If you guys have been to Springfield, Ohio, you'll know what I'm talking about. That's not a shocker. It's not the nicest town in the world. It's kind of rough there. So Tyler Wilson is the appellant. He's the person appealing. He engaged in a heated altercation with a guy named Billy Raffett at a gas station. According to Wilson's testimony at trial, on the charges of attempted murder, felonious assault, Wilson shot a gun out of his car in order to scare Raffett and make him back off. Wilson claimed he shot the gun in self-defense, but the trial court determined that because Wilson did not intend to kill or harm Raffett, he was not entitled to self-defense jury instruction. Wilson's trial counsel conceded a self-defense jury instruction was not warranted. So even his attorney said, yeah, Judge, you're right. So the Second District Court of Appeals, the intermediate court, also concluded that the facts of self-defense did not apply, and they found that Wilson's counsel did not... here's our guest, guys. I was mentioning we'd have a guest, possibly. Runkle, how are you doing?
I'm doing pretty well. How about yourself?
I'm doing okay. So, yeah, this is a... just started this real quick. So this is a case of, and I'll just rewind it a little bit. It's a guy named Tyler Wilson, and he was at a gas station. He was sitting in a car, and a guy pulled up in a truck named Billy Raffett, and he claims that Raffett pointed a gun at him, so he grabbed a gun out of his car and shot up towards him to scare him off. And the court at that time said because he didn't intend to kill or harm him, he couldn't claim self-defense. And his attorney said, well, that's actually that's a very common thing here. Up until this happened, most judges wouldn't let you do that because the argument they would make is you were using deadly force. If you were not that, if you're using deadly force, you have to be trying to use deadly force, not using deadly force as a scare tactic, is what they would generally say. I've heard this argument many times. And the judges crush it every time. And the courts of appeals in Ohio have crushed it every time. So, this is not uncommon at all. This happens a lot.
And I find this really weird because as much as Canada's not great for self-defense, we've had cases where they're like, it was reasonable to fire a warning shot under the circumstances. And when they talk about
why you can do it, it makes a ton of sense. When the Supreme Court says, "Well, wait, here's why you could actually do it," that that it makes a ton of sense why you could do this, and I fully agree with it.
I mean, there was one case where a guy, and this is in Canada here, where a guy was being threatened, and he says, "Hey, I got a gun, like, leave me alone." And now, to be fair, they're both criminals, so neither of them are good people in this story. But one guy's threatening the other. The first guy goes, "I got a gun, leave me alone." And the first guy goes, "Sure you do. I bet that's fake." And he goes, "Fake, huh?" Puts two into a trash can and says, "You feeling it? You feeling it, man?" And the guy's like, "Okay, we're good." And that was the end of the altercation. First guy, by the way, had a machete, so it wasn't like it was no reason to pull the gun out. And it's like, that seems reasonable. Whereas if you're saying he has to shoot him, I'm like, I don't know if I feel that.
Yeah. So we're just now getting through the beginnings of this here. So the Court of Appeals said that the self-defense didn't apply, and that his attorney didn't provide ineffective assistance by failing to request the instruction. But this is where
that makes it hard when you mix in an ineffective assistance of counsel argument.
Yeah, but the court, you'll see whether, and we're not, guys, this part right here is kind of their conclusion, but we'll get to the conclusion in a second, because I don't want to spoil it if you haven't read this or listened to it before. So the video footage captured at the Shell gas station in Springfield, Ohio is kind of a shitty town. So the fact there was a gunfight there doesn't really surprise me. I've been there before. I used to work down there a little bit. So on the morning of June 8th, Wilson was parked at a gas pump, and he was preparing to leave after he had gotten gas. His friend and the owner of the car was sitting in the passenger seat. Rafat, while he was on his way to work, stopped at the gas station. He, too, had a passenger in his truck. When they pulled up to the pump, he drove his truck in between Wilson's car and another vehicle. So they're just trying to get through to get to their spot. And this is where Wilson, okay, he did something, but why? Wilson began to yell that he believed that Rafat had driven too close and nearly clipped the car. Like, bro, you're at a gas station. Is this really where you're gonna, like, now he's sitting in prison before this appeal happened? Like, was this really worth jawing off about? Like, it's a gas station. It wasn't going 80 miles an hour down the highway. Like, the guy's trying to weave in and out of the cars.
I'm always stunned just at the stuff people end up in jail over. Like, when you go back, it's like, really? Was that worth it?
Yeah. Did you really have to yell at this guy? Like, he drove too close. I'm like, where the fuck is he gonna go? It's a gas station, man. It's inches off your dick, add years to your prison sentence.
The number of guys who have gone to jail over somebody bumped me and I spilled my beer on either side. Like, I had a guy at a bar at one point bump into me, spilled his beer on me, and he's like, "Hey man, that's my, you spilled my beer," and he's clearly looking for a fight. And I'm like, I'm just going to walk away from this because it ain't worth it. And if he'd pressed it, it would have been like, let's just get, I'll have a beer and this guy's going to have a beer. Like,
here, have one on me. Yeah.
Yeah. And, let's just, and then he can play, I've got the bigger dick, and that's fine, but I don't want to have to end up, I don't want to end up in a cell tonight or a morgue.
Oh, especially. And the other thing is, too, I mean, it's one of those deals where, it makes you look, you're the nice guy. I tried to get out of this. Look, he said I spilled his beer. Okay, cool. Here's another beer. Now you're the good guy. Like, I did everything I could to make this not a problem. So.
Yeah, absolutely. I always tell people, like, the direction you should be moving in a self-defense case is backwards, away from the thing, because it's always, even if there's like a witness there, you want the witness to be saying the other guy was advancing towards him as he was leaving and wouldn't let him leave. You take the Rittenhouse scenario and you have Rittenhouse moving forward. he's in a cell right now.
Mm-hmm. And the other thing, because I've had a couple of clients where we got things better, but I asked the guy afterwards, like, do you feel like you did the right thing here? And he's like, well, he actually wouldn't say no yet. And I said, tell me, like, you're going to sit in the cell for the next 7 years going, nobody fucking that's right. I showed him. I ain't getting disrespected. And you thump your chest every morning as you stare out the prison windows. Like, was that what was going to happen? Because the guy had a 3-year-old kid. I'm like, is that what you're going to tell your kid when he's like, Daddy, why can't you come home? Because somebody tried to disrespect me. And I got the guy to cry. He cried. We were sitting in the room afterwards, and he's like, he quit doing dumb shit after that. But I was like, turn your fucking life around, bro. And he worked a normal job and everything, but it was like, don't let everything be in a fucking affront to your ego. So Rafet then backed up his truck till his driver's side window was next to Wilson's driver's side window. The truck was so close to Wilson's car, he believed he couldn't open his door. You're in a car. You can drive away. Like, oh no, I can't go anywhere. It's like, well, he probably can't open either. But yeah, so now there's like, the guy's in the truck. He's higher than you. Okay, leave. Wilson also claimed that Rafet was only a few feet away, was hanging out of the truck window, and was spitting in Wilson's face. The two men engaged in a verbal altercation. And because he was in a truck, he was situated a few feet higher than Wilson, who was still in his car. Wilson then said that during the altercation, Rafet said, "What you gonna do? I'll smoke you out here," and pointed a gun at Wilson.
And that's time to leave.
Yeah. Well, at that point, the guy who Rafet says, "I didn't do that," or even having a gun. Okay, well, of course he's gonna say that. And the gas station surveillance cameras couldn't capture the angle between them to show whether or not there was a gun pointed at Wilson. Wilson testified he knew there was a gun in the car, and he grabbed it and aimed it out the window and fired up near Rafet's vehicle. And after Wilson shot the gun, Rafet drove his truck forward and turned around in the parking lot. When Rafet stopped to get his passenger got out of the truck, and Wilson claimed he was fearful the passenger was coming to harm him. It's like, well, yeah, that would make sense. So he drove away from the gas station, and Rafet chased him along Interstate 70, going towards probably towards Columbus, at speeds of 90 miles an hour, which is kind of like the normal cruising speed there. Now, notice here's part of the issue. They don't say this, but Rafet called 911, not Wilson. Call 911, guys. If you don't call 911, bad guys don't call 911, or stupid people. And don't be a stupid person either, because that's not a sympathetic look either.
And you don't have to say a whole lot on the 911 call. Like, hey, there's a guy with a gun. He's threatening me. I got to get off the phone, but, it's this gas station. Click. Like, even that indicates that you're terrified.
Mm-hmm. Yes. So eventually he stopped chasing. Now, I will say this is bad for Rafet. Eventually he stopped chasing Wilson and went back to the gas station, picked up his buddy, and went to work. And he didn't meet with the police until after he got off work, which that tells me there's a lot there, because if somebody shoots at me, guess what I'm doing? I'm going straight to the cops and saying, "Oh my God, this guy tried to kill me." Not, "Oh, I'll go to work and then deal with it later." Once again, there are some facts here which makes you think Rafet did have a gun, just on the way he's acting. So, during getting chased, Wilson's car ran out of gas on the highway, and they tried to push the car off the road. During that, the passenger fell and got run over by the car, which that's gotta hurt. Yeah.
I mean, it's tragic for the person who got run over, but it's always just, you picture these things. It's like, ugh, this is becoming a little bit of a yakety sack situation here.
Mm-hmm. Oh, I know. These are never flattering situations, guys. So that's the other problem too. People are gonna, this whole chain of events isn't flattering. They sound like idiots. So, but it's there forever now. When they stopped to help out, they ran his name and they found he had unrelated warrants, and they took him into custody. which, brilliant. Which I also understand that's why he didn't call 911, but still, you got warrants, man. That's like, clear your warrants up. He was later charged with attempted murder and felonious assault. At trial, and he testified in his own defense, and his attorney asked, did you intend to shoot him? And he answered, no, I intended to scare him and back him off because that man had a gun to me. And either way, he had a gun to me, so instinct, I grabbed the gun as fast as I could to protect me and the passenger.
Now, I'm just going to say, if somebody unjustifiably pulled a gun on me, I'm thinking my warning shots would probably be like, warn to the chest, see if he needs further warning.
Sure. I mean, I would think so too. And that's part of the argument why the court made the initial court made the argument it did here. So later on in his, direct, did you intend to shoot him? Nope. Did you intend to murder him? Nope. All I wanted to do was make noise to get him out of my face, which his attorney should have worked with him on it, saying I wanted to make noise to get him out of my face. I don't think that's not a, and this is from the transcript. That doesn't sound good. I don't like that. I just wanted to make some noise. It's like, and that man had a gun to me, and I don't even know how. I got one shot out of the vehicle, and it did its job for real. He got away from me, and the car wouldn't start, or would I've had a little more time to get away. On cross-examination, he denied that he attempted to harm him. And he's like, did you aim the gun at him? Nope. Did you fire your gun at him? He's like, I fired the gun in the air. And that said, though, the prosecutors tried to show that there's a dent in kind of like the frame of the truck right by the guy's head. There's like a circular hole or dent. But it was never confirmed that it was a bullet hole because they never really inspected it. So it's not clear what that came from. And I'm assuming it's kind of like a shitty truck that's probably all beat up anyway. It's not like a brand new truck off the lot. So they're saying, now you're saying you didn't. Now you're saying you shot at him, but he's like, and it's where the prosecutor's going to trip you up. You shot towards him in the direction of him, but you didn't mean to hit him. But they're saying now you shot at him. And see, this is where the prosecutor will trip you up and come after you. Because you didn't cause that dent. And he's like, I shot out my window to make noise. Like I said, that has to get, that is an awful answer. I shot out the window to make noise. But, it's Clark County. Clark County, Ohio is not full of bright people. He never testified any differently or recanted his statement that he shot out the window. And that actually is good in his, argument. And while he initially presented a theory of self-defense, his counsel abandoned that theory at the suggestion of the trial court. The defense counsel conceded the self-defense instruction wasn't warranted because Wilson admitted in his testimony he did not intend to harm him. The jury found him guilty of felonious assault with 2 firearm specifications, but not guilty of attempted murder. So what happened to him was he had 2 firearm specifications. The first one was because he used the firearm in the commission of a crime. So that's 3 years. It's 3 years mandatory, and it's 3 years that you have to serve first on your sentence. So you might get one, like your underlying felony might only get you 1 year in prison, but the gun spec gives you 3, so you automatically have to do 3 years, and then maybe you get out and then serve your 1. So he got the 3-year firearm specification. Because he was in a car, under Ohio law, he could get charged with a drive-by specification for using a gun in a car. That's 5 years.
Oh, God.
And because there's separate specifications.
I hate all the specifications that you get in American law.
So they stacked up.
Yeah.
And they stacked up. So now it's 8 years, and it's 8 years mandatory prison time. And the judge he's in front of, a judge named Judge Rastatter, I've been in front of him only a couple of times. Because I was a assistant prosecutor in the county directly north of them. He isn't afraid to hand out like plane tickets and send people to prison. He hands out, people ride the bus, as they say. He gave the guy felonious assault. You face a sentence of 2 to 8 years in prison. It's not mandatory time, but under Ohio's laws, there's a presumption for prison. So he was given a maximum sentence of 8 years. So he has a 16-year sentence and eight of it's mandatory. And he got sentenced in 2021, so he's not getting out till 2027 or 2037. Yeah, he got nuked pretty bad. But that's the cost of if you take a shooting to trial and you lose. Generally, it doesn't go well. So on appeal, the second district argued, in the second district, the appeals court, he argued his counsel provided ineffective assistance by failing to request the instruction, and the Court of Appeals rejected his argument. And it would have been 3 judges, so it was 2-1. The majority concluded the instruction was not available to Wilson because he didn't concede he intended to harm the guy. To the contrary, the majority found that Wilson had attempted to negate the claim he committed the offense of felonious assault by testifying he did not intend to harm the guy. So, and they're arguing that because self-defense presumes an intentional, willful use of force, when an individual testifies that they did not intend to cause harm, such testimony prevents the individual from claiming self-defense.
And that's that annoys me because it's like the display of the gun is a use of force.
Yes. and that's actually not an issue. I've had cases and I've seen cases where displaying the firearm, that's okay and it works out. But yes, this is that argument I was trying to tell you. In Ohio, a lot of judges look at it as, well, if you weren't intending to hurt him, you shouldn't have been using deadly force like that. You should have done something else. So the dissenting opinion countered and said he was entitled to self-defense instruction because he testified the purpose for firing the gun was to repel a perceived attack on him. And repelling an attack is self-defense. And he pointed out the majority's opinion encourages an individual only to shoot to kill or maim when confronted, saying there's no other option. You have to kill the guy, not just scare him off. So he appealed this to the Supreme Court of Ohio, and they accepted the jurisdictional argument, which in Canada, is there like a court of Alberta, or does it go straight to the Canadian Supreme Court?
So there's provincial court, which is the lowest level. Yes. And then there's King's Bench, which is in some places called Superior Court. And then after that, there's the Court of Appeal. And then there's the Supreme Court.
Okay. And I'm assuming just like the U.S. Supreme Court, getting your case heard is pretty much shot in the dark.
Yeah, they don't hear a lot of cases.
Yeah, and to get it in Ohio, guys, and just so you know, your state Supreme Court is probably going to be the same way unless you happen to live like in Alaska, where there's not a lot of people. It's very hard. It is very hard. They have a lot of discretion to not hear your case. The only things they have to hear are like death penalty cases. Other than that, there's a good chance you're not going to be heard. So they do point out in their argument, and they say, though, ultimately, because Wilson, through his testimony, fired the shot to scare or repel him, and he produced evidence that tended to support the claim he acted in self-defense, we conclude he was entitled to the jury instruction that his counsel was ineffective for not requesting it. So this issue about the improvidently accepting it, this is a lot of dorky stuff, guys, that I'm not going to get into with you, just because it's about the jurisdiction and whether or not they should have taken this. But the court just says, well, this is a 7 judge panel, the Supreme Court, and it was 4-3. So it was a very divided court on this one. And the part of the court objected because they thought it shouldn't have been accepted, period. So let's actually get to the actual intent issue. The intent required for self-defense. And at the time of this, and this is where we do have self-defense actually codified finally. It's not just case law. It took us forever to get this done. A person is allowed to act in self-defense, defense of others, or defense of that person's residence if at the trial of a person who is accused of that offense that involved use of force, there's evidence presented that tends to support that the accused person used the force in self-defense, and and defense of another, the prosecutor must be on a reasonable doubt that the accused did not use the force of self-defense. And that. It took us forever to actually get this written down because for the longest time in Ohio, it was on the defendant to prove it. Now, most courts and most judges still made the prosecutor prove it beyond a reasonable doubt. But under the strictest reading of the law at the time, it was the defendant's burden. So that is something we got done there. But they point out if there was evidence presented at trial that tended to support Wilson had used force in self-defense, the burden shifted to the prosecution to prove beyond a reasonable doubt that he had used force in self-defense. And they point out that he provided enough evidence to claim he did. And this is the big point here. The state can't point to any language in the statute specifying a defendant must have acted with an intent to harm or kill in order to assert and be entitled to a self-defense instruction. And that's actually very important because there's no argument you have to do that. And I think that's a good thing, ultimately. We don't want... you don't want people to... as the court said, and I think you agree, we shouldn't be forced to kill people if we don't have to. Because if we do, that's...
Like, hey, listen, you didn't kill this guy fast enough, so you don't get to use self-defense? It's kind of a weird, like, you have to go from, like, 0 to 100 with no break, like...
Yeah, there's no brakes on this train. Yeah, you've got to...
If somebody wants to be reluctant to kill somebody, that should be something that's okay.
Yes.
Now, I mean, under the circumstances, if somebody's got a gun pointed to your face and you shoot them, I think that's also reasonable. But that doesn't mean it can't be reasonable to take lesser steps.
Exactly. But that's... Yeah, and this has been a argument I've heard multiple times, and courts generally just say, "Don't care," and I actually seen courts almost vapor lock it when you make that argument, and they say, "Well, that's actually not what the statute means," and thankfully the Supreme Court's finally agreed and said, "Actually, that's what it does mean," and your argument doesn't work. So, as there is no statutory support for the state's claim that you must intend to kill or maim someone, they turn to case law. And self-defense does not require a particular mental state. In self-defense claims, the case law specifies the intent necessary. For over 100 years, self-defense presumes intentional, willful use of force to repel force or escape force. And they cite a case going back to 1924. But yes, repelling force. Well, that doesn't say killing somebody. It just says stopping the force against you. This means that the force must be intentional, not accidental. And that's different. And that's where I think courts try to make the claim of, well, and you hit him. Well, I accidentally did it then. And that's where, okay, fine. I wasn't trying to hit him, but I did hit him. Yeah, you might be in trouble there. But I clearly intended not to shoot the guy, and obviously I didn't hit the guy. But they go on. The only additional intent required is the intent to repel or escape force, not an intent to use force to harm or kill another person. Wilson's use of force was intentional. He admitted to grabbing a gun and firing it. He did not claim he fired the weapon by accident or the gun went off at random. He also testified he used the gun to escape or repel him and to scare the guy off and back him off. Which
doing something to scare somebody is a use of force. Like if I come up to Sean and go, "Hey, give me your wallet," I think he would feel that I was using force against him. And I think that the courts would probably have no issue with concluding that I was using force against him and so forth. So, yeah.
Oh, do you work for Keebler? I was wondering who you're typing to.
I said, no, they stole my likeness. I'm suing.
Now, this part here, though, this is the one part about Ohio I do not like. Our actual elements of self-defense are not codified, unlike a lot of states. This part still is just in case law. And the elements of self-defense in Ohio are you're not at fault for creating the situation, giving rise to the affray, and 2, you had a bona fide belief that you are in risk of imminent danger of death or great bodily harm, and your only means of escape were the use of force. Because this happened in 2021, though, they have to use this part here, part 3. Is this going to change if I mess with? Okay, hold on here.
Man, I hate 2 elements of your test.
Okay, well, this part here did not violate the duty to retreat. This is gone right now. As of today, this is gone.
Oh, good.
This has been actually removed by state law. The duty to retreat has been eliminated completely. So that's gone. It's done.
I mean, Canada, depending on circumstances, may have a duty to retreat or a, it could be a consideration as to whether or not you could have. But, like, it really depends on the circumstances. And in your house, there is no obligation to retreat from your house.
Yes.
So, like, sometimes people say, like, Canada needs castle doctrine. It's like, castle doctrine is that you don't have to retreat from your house. Canada's got that.
Yes.
But I also don't like the not at fault in creating the situation giving rise to the affray, because sometimes there are situations where people can be at fault and should still have some right of self-defense.
Well, in Ohio, you just have to then show, like, well, being at fault means you were doing something unlawful or you didn't have the right to do what you were doing. So if I bumped into you, yes, I'm at fault for starting the whole situation and you spill your drink. But the court's not going to fault me at that point because, I spilled your drink, therefore I no longer have self-defense rights. If I had shoved you or done something illegal, then I would have to withdraw or attempt to withdraw to gain self-defense back. And to say, look, and there is case law just saying, like, look, I don't want any trouble. I'm sorry. Like, putting your hands up and just backing away can get you that back. Now, if you try to take a step or two back, then that's even easier to get it back.
Yeah, I'm just thinking of, we've got situations where, like, guy gets into a bar fight, and throws hands for a bit, and then the other dude pulls a knife, and it's like,
well,
okay.
Well, and yes, if there's escalation, though, that also kind of negates. You're now faced with disproportional force. So I without looking off the top of my head, I think you'd be able to make a valid argument. The force was drastic. Like, this person's escalated beyond what you were doing, and you're allowed to respond.
Gotcha.
Because you're not, and there's a case we had once where it said, like, you're not expected to flee in the face of wanton violence. So at that point, once it's on, it's on. But yeah, there's no more duty to retreat, so that's good news. They say our case law requires only that you have the requisite. That's too. The requisite state of mind of intent that a defendant must have to assert self-defense, that he or she intended to use the force, and that force was used to escape or repel the attacker. Does not require any state of mind, let alone to kill or maim.
And repel is exactly what we're talking about.
Yes, he scared him off. It was funny because when I read this on Monday, somebody said, well, can you use this in other types of self-defense? And I said, unless you, like, only projectile types of defense, because if I have a knife, I can't really, like, warning slash you or, like, I mean, maybe kind of, but
I mean, I could be sitting there going, hey man, back the F up, or I'm about to,
Well,
I mean, you could take a swing and check the swing or something like that, but still, I don't get it.
Yeah, no, I think it's generally limited to, like, if you have a gun, okay, if you have a bow and arrow, okay, that would be a projectile weapon. You could fire a warning shot. If you're Achilles and you got a set of spears in your hand, you could throw one of your javelins, and the next one's gonna hit. And they said that a jury could believe or disregard the testimony, and they could determine whether or not he was at fault in creating the situation, because Rafet pointed a gun at him. And that two, did he have a bona fide belief that he was going to get shot? Because Rafet said, "I'll smoke you out here." And then,
I mean,
according to
that
Wilson,
seems
pointed
to
the
me to
gun.
be a pretty good
Yeah.
bona fide belief.
Which he felt scared for his life, and he thought the only means of escape was to shoot out the car window. And then the duty of retreat thing, because that still existed.
It feels like it would be unreasonable not to be afraid for your life in those circumstances where somebody's pointing a gun at you saying, I'll smoke you out here.
And that's the thing, though, because when you get back to whether he's at fault, you're allowed to say, hey, man, you almost hit my car. Be careful.
Yeah.
And that kind of goes back to that whole thing you're worried about. Well, if I start something, am I ultimately on the hook the whole way? And no, if there's intervening events that can take it out of your hands. So they imposed, and they point out that everybody else, the other courts imposed an additional lawful burden of production by requiring him to admit that he, intending to kill or harm the guy in order to proceed on a self-defense claim. And because of that, they've read words into the statute that don't exist, and you can't do that.
I agree. Like, their reasoning seems crystal clear here.
I agree, but I'll explain to you why this is not 100% legit, like 100% guaranteed.
They might get it flipped.
Well, the way this got decided was not the best ground. Like, if you read this, when you get to the end, you'll say, okay, I see why they're fighting.
Ah, gotcha.
So that he presented an affirmative defense. And they argue that he could not proceed on self-defense because he was not presenting it as a true defense, but rather as a negation of intent. And yes, he could also say, I'm not guilty of felonious assault because I didn't intend to cause harm. That's a separate argument. I used force to repel this guy, but I'm also not guilty of harming him because I didn't intend to harm him. And I think that the court here does a good job of this because his attorney, I don't think, made this distinction. Self-defense must be a true defense rather than a justification for conduct and not a negation of the elements underlying the charge. And that's true. It's a full admission. I did it and I had a really good reason for it. He didn't attempt to negate the intent required for felonious assault, but he did try to justify it. Unlike self-defense, a state of mind required for felonious assault is set forth in that you have to knowingly cause or attempt to cause physical harm by means of a deadly weapon. And knowingly is when you act regardless of your purpose, when the person is aware their conduct will probably cause a certain result or will probably be of a certain nature. And, firing a gun off, you have to presume I'm knowingly going to cause harm. Because you can't say I didn't know that it could do that because it's a gun. You know what it does. And his argument is, well, I used that thing I thought was going to kill me. I used it back. So, and that's a fair point. Intentionally shooting in or toward the vicinity of another person where there's risk of injury meets a knowing element of felonious assault. And this is just all the different cases they cite here. A guy firing multiple shots, firing a gun in someone's direction is sufficient evidence. Shooting of a gun where there's risk of injury is enough. And they just kept on explaining all the different cases. And it's all like out of Columbus or Cleveland or Cincinnati. It's like, yeah, they have a lot of shootings in those towns.
And I love how the case law tends to be unevenly distributed for shooting stuff.
Yeah, well, there's 88 counties in Ohio, and there's only so many of them where there's going to be shootings. Like 4. Well, the dissent argues this is too narrow. On the contrary, the dissent's position is too broad. They read the knowing element out of the statute, argues Wilson needs to admit that he intended to cause harm. And the dissent makes that argument. As explained above, for more than 30 years, courts across Ohio have consistently found that intentionally firing a weapon in the direction of another person is sufficient to meet the element of knowingly. And yet, when it comes to self-defense, courts have turned around for the past 30 years saying that doesn't count. A warning shot doesn't count. If you miss, that's bad. But if you're firing a warning shot, well, that's even worse. If you intended to miss, it's even worse. Which, yeah, I think that is such a horrible argument to make. Intending to miss is worse than being accidentally missing. So, No, go
This
ahead.
is also one of the reasons why defense lawyers say don't talk to cops.
Yes.
Because the guy could be there saying, and he's got the best of intentions and said, I just fired a couple of warning shots. Whereas if he shuts his full mouth, defense lawyer could say, you don't know if those were warning shots or if he's just a real shit shot. He was trying to cap that guy in the face. He just happened to hit, like, I don't know, the broadside of a barn some distance away.
Yes.
Prove that wasn't just a shitty shot.
Yeah, and that's the true part. And that's why, yes, guys, when you talk to the cops, it makes it really hard for people to do their job afterwards.
The other one people say is like, just say it was a self-defense anything. I had a file where this guy kicks down a door and encounters a family, gets the shit kicked out of him, and then the cops, like, he goes, like, flees off to the hospital, tells the cops where this happened. Cops come by, nobody says a damn thing. And the cops end up going, we don't even know who to charge. Somebody kicked the shit out of this guy. And it might be self-defense, but we'd let the courts sort out that. But if we can't even figure out who kicked the shit out of this guy, and there's 4 people in this, in this family, we don't know if it was Papa Bear, Mama Bear,
or the baby
or Baby Bear, right?
Yeah.
Like, maybe the toddler kicked the crap out of this guy.
Yeah. Or maybe he fell down the stairs.
Yep. So,
we live in an accident-prone world. It's like The Simpsons. The waiter didn't get beat up. He just was very clumsy.
Exactly. So, yeah.
Yeah. No, I mean, and that's where, people can laugh at that, but they have to prove it otherwise, and they can't. So, and they just keep going back to this. He admitted multiple times that he pointed the gun out the window and fired a shot, but he didn't intend to strike the guy. And they talk about the dent in the truck being allegedly caused by the bullet. Wilson stated, I didn't aim at the vehicle at all, and he was so close to me, the bullet couldn't do nothing but probably hit there. But yeah, it doesn't mean anything because you don't know what happened there. And the question is not whether the evidence should be believed, but if believed, could convince the jury that he acted in self-defense. But they point to another case where they had overturned a similar situation where the guy both fired shots toward another person, and that led them to, shoot, except Palmer actually hit his assailant. And both men were found not guilty of attempted murder, but guilty of felonious assault, and both men were denied a self-defense jury instruction. So, just like in Palmer, a jury would be free to believe him or disregard his testimony, but he's allowed to have the instruction read because his testimony was enough. And it doesn't take much to make self-defense, my guy saying I acted in self-defense is enough in Ohio.
There's a fun case in Canada of 2 guys are out hunting. One guy's an idiot, so he sees a shape and shoots at it. And he's also a shitty shot, so he misses.
Oh.
The second guy, he can tell he's being shot at because there's a bullet that whizzes right past him, sees the first guy shooting at him, and turns and shoots at the first guy, and then is ultimately shot by another shot after the first guy realizes he's being shot at and shoots again. And so the question is, who enjoys self-defense? And the answer is both of them.
Yes. Yes. Mistaken parties can have, if you have a legitimate belief, even if it's mistaken, or it was, and this happens as shitty as it sounds like when the cops break into someone's house at times. The cops hit the wrong house and they both start shooting. Well, in places that aren't complete scumbag jurisdictions, yes, both sides do have self-defense at that point. Although I'd argue the cops shouldn't enjoy it because they know what they're doing when they start it. But yeah, both hunters are like, oh my God, wait, someone's trying to kill me now.
Yep. And it's like, sure, this all got started off on an accident, but both of them are correct that somebody's trying to shoot them. So
yes.
Yep.
Did they both end up getting charged and going to trial, or?
They both ended up getting charged, and they both ended up. I think one of them was acquitted and one of them took a plea deal for something lesser and probably felt bad afterwards when he saw the other guy was acquitted. So neither of them died, which was good.
Yeah.
But one of them does get shot in this whole
in
this
altercation.
altercation.
Oh, so then it turns into a gunfight between Fuds.
Yeah.
Which are shooting each other through their NRA hats.
Well, I go hunting and I've gotten pissed off at people before when it's like, buddy, you need to have 2 sets of optics. You need to have the one on your gun and the one you look through to go, is that a deer or not? Because don't point your fucking gun at me.
Yes, that is not meant to be. That the scope is not meant to search.
Yeah. So, and you get people who are like, why are you carrying binoculars around? Don't you have a scope? It's like, so.
Yeah. Well, that's why when I'm wherever I go, I always try to find like a tree. I get people are gonna make a joke, but I generally try to put my back up against a tree or something solid, and people are thinking, "Wow, are the trees really that big in Ohio?" Sometimes there are, but I try to find something behind me, and then usually I have like an extra vest, and I'll put it up high enough above me where, in the chance that I actually do get shot by some dumb fuck, it's gonna be really hard for them to say I didn't know anybody was there when there's like a big piece of orange sitting like 6 feet off the ground ahead, like above my head.
Big orange arrow that is like, don't shoot me, please.
Yeah, well, that's because like there are because I've been in the woods before and I've heard bullets go whizzing by.
We also had a case here where a guy got shot, but it was he was carrying a deer out.
Oh,
and so he was literally
that's a little more understandable.
Where I am, you're not required to wear like orange or blue or anything like that. So he was in camo carrying a deer, and I'm just thinking, okay, I like hunting in camo too, but I will tell you, I wear a reversible outfit, and when I'm done hunting, it's like, let's just slap the orange on. Or in situations, if you're hunting somewhere that's like dense, it's like, all right, I'm not hiding. I'm just gonna wear the bright freaking neon because I don't want to get shot by one of these jackasses. And
wearing camo's fine, but when you read about like Fredbear and all the old timers when they used to go hunting, what they wear? They wear flannel, and they go kill something. I mean, they're deer. They are dumb enough. They run in front of cars all the time. Like you could sit there like in shorts and a t-shirt probably and kill them.
I gotta say, I was really annoyed the one year because I spent like 3 days in the bush waiting for a deer. I didn't see a damn thing. Got into my car and then watched some guy in a truck accidentally smoke a deer that just ran out of the bush in front of his truck. Like thump, screech. I was like, motherfucker.
Well, I had a stretch for about 5 years in a row where I killed a deer every year with my car, and that was it. So,
that's the most expensive way of.
Well, yeah. One of the nights we were driving home from, when I was married. We were looking to buy a new car, and we were like, oh, we're just checking to see what's out here. And we were leaving the lot, and we're driving home. We're like, oh yeah, do you think that car's a good car? Just right into it, and it totaled the car. And what better way to find out? I guess we're buying a car soon than killing one on the way home. So, the best part about it though was I broke its back and it was still alive. Ooh. And it's there flailing in the road, and the police get there in time, and the cop. I go back, sit in the car because it's the middle of summer, so like the mosquitoes are out. And the engine's still running, and I'm like, I'm just gonna run it till like the car's totaled. I'm just like, I'm gonna keep the air conditioner going till the car dies.
Yeah.
And it ran for a while. And my wife's sitting there, she's like, well, what's he doing? And she sees the cop, he goes in the back of his car, he pulls out his earmuffs and puts them on. She's like, what's he gonna do? And I'm like, what do you think he's gonna do? And he walks
he's
up
gonna do first aid.
Yeah, he walks up and just drops it. And I'm like, she's like, oh, and I'm like, that was the best thing for them. If I could have used my concealed weapon and done it, I would have done that instead. But I didn't want to get a game violation for that. So
that beats the hell out of we had a cop here who got in some shit because he came upon a scene of people where there was an injured deer, and he decided that he didn't want to shoot it. So what he did was he drove over it repeatedly with his patrol vehicle.
Why did he want to shoot it?
I think because there's paperwork if he discharges his firearm, and so he was just like,
running it over?
And it didn't die. Bump, wasn't dead yet. Bump, and it took like repeated.
Tell me this is on camera.
This
era.
Was all like there were also like a whole bunch of people there watching this. So
that Mountie rules.
It was just it's one of those things where it's like, oh my god, just get out your service weapon.
That's very cruel, but I kind of want to see it because I wonder how funny it looks. I wish this was at cell phone or smartphone time. Oh, God.
It's just like, buddy, you gotta know, like, yeah.
So, well, let's keep going here for a minute. But oof, I'm gonna. Oh, that's so funny. That's almost like Me, Myself, and Irene when he tries to kill the cow.
That one I haven't seen.
Keeps shooting. Jim Carrey, he keeps trying to shoot the cow and it doesn't die.
Oh God.
Oh. Kimbo says that cop's name was Nick Rekieta.
Doesn't Rekieta have guns?
Yeah, but I'm not sure which joke they're making because there's a lot of jokes you can make, so it's hard to tell.
I don't know if it'll let me drop a link in your chat, but I'll drop it in the private chat here.
You should. I think you're a mod. I think I wrenched you up.
Just for no, it looks like it failed to post. So
send it to me.
I put it in a private chat there. But if people want to read about the officer who repeatedly drove over the deer,
this sounds funny. What year is this? Oh, for 2019. So they would have had smartphones. Too bad. Too bad nobody filmed it.
They did. There's a video.
Oh my God. Okay, we're gonna have to watch this at the end then.
Okay.
Okay, so now we get to the ineffective assistance of counsel part, and guys, the ineffective assistance of counsel standard is Strickland v. Washington. That's Supreme Court. That's from all over the country. This is the standard. So to prevail, you have to show the counsel's performance fell below an objective standard of reasonableness. And then there's part 2, but part 2 has 2 parts to it. That the counsel's deficient conduct prejudiced him, and that it resulted in a fundamentally unfair, reliable outcome. So there's actually kind of like 3 parts to it. Did it fall below a standard of reasonableness? Was it deficient, and did it cause you prejudice? And then even if those 2 were there, did it cause an unreliable outcome? If that part's still not met, that 3rd part, that's usually where you run into problems. Would it actually have changed anything, or was there even a chance of changing anything? If not, it doesn't matter.
And that's very similar to the test here in Canada as well. So
yeah. Oh yeah, look, yeah, it was bad. Sure, it wasn't good. We didn't like it, but it wasn't going to change anything.
And the problem is wasn't going to change anything is often like, how would you know? It's like counsel slept during trial, but the evidence was so overwhelming. It's like, well, maybe it wouldn't have been so overwhelming if a good lawyer had been able to challenge some of that.
Yes, or just asked a couple of questions. Like maybe there's just one question he could have asked, and it all falls apart.
Officer, did you lie about this whole thing? Yes. No more questions. Like that. Yes. That might.
I agree. Yeah, it doesn't take much. Okay, Duncan, real quick. Saying, how does it make sense the only way to claim self-defense is with an intent to harm? Seems kind of stupid. I don't disagree with you, but that was the way courts and mainly prosecutors had made this argument, and courts bought into it. So, Duncan again for $5 says, no. No, you have presented your weapon. You must finish him. Seems like Klingon law. It does. It does sound like it's, or the Dothraki. You have unsheathed your sword. It must only go away bloodied.
Or Dune. Like, this is
Yeah.
Duncan, Idaho,
Yeah,
and
I know
the
at
whole
Duncan, Idaho
Chris
as
knives
well.
have
Yeah.
to be bloodied before they put. Come on, man.
Yeah. I it didn't even occur to me at the second there. Yeah. Uh, and then Philip Kogan's for $5. Thank you for both of those, Duncan. And Philip for saying at $5, saying, Mom hit deer. Deputy was a quarter mile behind us. The deer was still alive. The deputy finishes the deer, walks over and asks my mom if she wants the roadkill license. Well, they asked me that here too, but the deer I hit, the last one I hit, well, the last one I hit was a fawn, so it was like a mess. But the one where we totaled the car, like driving home from the car dealer, that deer was like completely destroyed. So no, that would not have been really. That would have been a lot of work to make it edible. So
They've stopped giving roadkill licenses here if you hit the deer,
oh, they do.
because there were too many people who would go buy a shitty car and then hit a deer with it.
Really?
Um, yeah, they'd go buy the cheapest car they could and go smack a deer. Um, I have pulled a road. They'll still give them to you, but their requirement for it now is it has to be that it's not safe for human consumption.
Oh.
So I got one that was starting to get a little ripe, and I still harvested it. It was roadkill,
Yeah.
for the dogs, and the dogs
Oh.
loved it.
Well, I'm sure they ate well.
Oh, they just thought it was the greatest thing ever, and I made something out of the hide. So,
oh, there you go. That's where you can act like you're a Haitian gang leader, and you're like, that's okay. I'll just throw it on the fire anyway. I'll show you one safe for human consumption. So, they say that while we defer to a trial counsel's decision as a matter of strategy, there's little doubt here that Wilson's counsel failed to request it. The only defense his testimony supported, and this footnote, which I love footnotes. This is the way citations should be. Even case citations should be in footnotes. In his closing argument, Wilson's counsel argued that Wilson may not have been the shooter. Even though Wilson testified repeatedly, he fired his weapon. And I don't.
It's bad if you're having to argue. Don't believe my lying client.
Yeah, I don't know who this guy is. I've never heard of him before. But I don't know what the fuck. Like, what kind of argument is that, dude? When the first time I read this, I thought that was like a misstatement. But no, I read the appellate court decision, the one below this, and the guy's actual like that part of the transcript is in the opinion, and I'm like, wow.
I have had to run an argument similar to that once, where it was like, don't believe my client. But the whole purpose of putting my client up on the stand was literally just, all right, we're going to watch, like, I'm going to show you what happens when you try to get this guy to tell you what happened during his day, because he's so badly mentally ill that the context of his confession is you should not believe that his confession means a damn thing. And by the end of it, the prosecution was just like, oh,
yes,
we probably don't really want a conviction on this. So, yeah.
Well, there you go. That works. But yeah, this one is that I can't believe he made that argument. Like, maybe he didn't even fire the shots like he said he did. Well, maybe he's wrong. It's like you don't want to ever you don't ever go in front of a jury. I've always looked at it as you don't ever want to say words and plant things in their mind. So if I say the word prison or convict,
yeah,
now that's in their mind, the word convict, and like every time you hear that word, I always treat it like you're kind of filling that, like that jar that's in their mind. You fill them with the word convict, convict, convict. Well,
so
eventually that's all that's in there.
You're saying you wouldn't have done Bowles' closing of like, did you see how the chief or how the what is it? Wasn't the chief? It was her coworker was saying, "Oh my God, this is egregious. She's got to go to jail." Did you see that? Like,
yes.
Why are you telling the jurors this?
Well, there's a lot there. I would have not done a lot of things he did.
He made some choices.
Yeah, he did.
And
I mean, apparently, yeah. Well, you told me he's free, so
he got to do a lot of the fucking around, and she's doing a lot of the finding out.
Well,
so
I think a lot of people are finding out he's not somebody you want to hire.
Whew.
Yeah. So they do point out that if you fail to request a self-defense instruction in certain situations, that may satisfy the first prong. And notably here, the dissenting court does not attempt to distinguish it. The second prong is also met. Juries are entitled to all instructions which are relevant and necessary for them to weigh the evidence and discharge its duty. So the jury found him not guilty of the attempted murder charge, which suggests the jury had some question regarding his intent. Further, it's unknown who the jury may have believed and how it may have weighed the evidence if it was instructed to consider Wilson's claim of self-defense. There was conflicting testimony from the two guys. The cameras couldn't show it. That's a lot of reasonable doubt right there.
I also have a question here. Mm-hmm. How does the court say we're not giving an instruction on self-defense when there's specifically an attempted murder charge, which would mean that the prosecution's case hinges on an intent to do harm? How does that not get you?
Because from what I understand at the trial level, they made this argument of, well, when he's saying I didn't try to hurt him, I'm negating my intent. And if I'm negating my intent, I'm not entitled to the self-defense instruction.
But the prosecution is alleging intent.
Yes.
And so if they made out intent, then the self-defense has to be live again.
I don't disagree with you. I don't know how well the attorney made this argument at the trial court, but this judge that they were in front of is, he's also a judge. He used to be a prosecutor. I'm not saying that he's, pro-state only, but I think that's probably how it shook out. Ultimately, though, the defense attorney did not help things here, and I'm sure he didn't make that good of an argument. And this, I think, just comes back down to, this doesn't mean he had to be a gun guy to do this, but you just have to be able to, attorneys who are more Second Amendment focused or more firearms related focused would make the arguments necessary to look. He had the intent. Get away from me. I don't want to hurt you, but if you force me, I will. And he scared him off. If he had pulled the firearm out and waved it, that's repelling the attacker, and yes, I think that this could have, I just think this wasn't argued properly by the defense counsel. Because after a while,
agreeing.
Well, after a while, he basically says, judge is like, look, based on, they had outside the jury, he's like, look, I'm looking at this, he's not entitled to self-defense based on what I see, and the attorney's like, okay, yeah, I kind of agree, judge. So he didn't bring it up. So, J-Rock says, Sean, we know you aimed that car at Bambi.
No, it was Bambi's mom.
Yeah, you know what? Yes, I did. And I enjoyed every second of it. And then Duncan Ido says, yes, Freeman Law. I meant Freeman Law. Yes, he's like, you're right. I messed up. Oh, so getting down to the conclusion, yes, they point out that under the evidence, Wilson was entitled to the jury instruction. Therefore, we reverse and send this matter back down. So he's getting a new trial. And I forgot to open this up before I got here. Well, actually, because we got back a little late from the airport. Let's see here. Clark County Clerk of Court. Legal Division. Where is accept court? I'm not a robot, I guess. Maybe. Okay. Wilson Tyler. Okay. Okay, yep, his case here, it's getting reopened. So, he had a court date, I think, this past week. Yeah, okay. He had a hearing on 3/14. His bond was set at $100,000 cash or surety, which is just that's a big fuck you at this point to him. So yeah, here's his bond. He's back in the jail, but he's on $100,000 bond. Not like the judge, like, maybe there's something here that I missed.
Yeah.
Nope, $100,000 cash or surety, meaning he can't post 10% with the clerk. He's gonna have to find a bondsman to throw up 10 G's, or find somebody to put up $100,000. So, yay.
That's a lot of money.
Yeah, it
and
is.
I can tell you, if you're trying to borrow, if you're trying to borrow money for bail money, banks are not super thrilled by that unless you've got like the equity.
Nope. Yep, and so the Supreme Court of Ohio, and this is where you can see there's 7 justices on it. You might call them 7 injustices. So here's So here is the breakdown of them. You see here, Donnelly and Bruner, they concurred. Fisher concurs in the judgment only. Okay. And then, who did this up here at the top? Who wrote this? Stewart announced it. So notice that they're pointing out that the one judge is like, I only agree with the outcome. I don't agree with the reasoning. Which, that's something to consider. That doesn't mean he supports this. And then the other 3, Dieters, Kennedy, and DeWine, dissent. And yes, those of you wondering, DeWine is, yes, he shares the name of our governor.
Huh.
Yeah.
What a coincidence. I'm sure that is.
Yes. Yeah, and I mean, it's almost like, it's almost like, Pat DeWine's dad is the governor, Mike DeWine. So, yes, he's the son of the governor. But this
what a startling coincidence that I'm sure has, yeah.
But here's the point of what happened here. So you have Donnelly, you have Stewart and Brunner. Well, what are they? They're Democrat. And then Fisher agreed. He's a Republican. But then you have DeWine. He disagreed. He dissented. He's a Republican. The Chief Justice is a Republican. And then Joe Dieters, he got, he just joined. He used to be the former prosecutor for Cincinnati, Ohio, in Hamilton County. So, yeah, imagine that the guy who's, kind of like very pro-state is not cool, was very pro-state. So that's why this is 3-4 with the Democrats. And if, I don't know if this is I don't know if it's safe.
Which side was Joe there on?
Joe Dieters, he's a Republican. He dissented.
Okay.
He was a dissent. So there were the ones I circled were the dissents.
Which is weird because you could also read his name as like Joe Deters.
Yes.
You'd think he'd be okay with that.
Yes. I don't want. Yeah. Well, that'll be funny if he gets ever attacked. It's like, but you didn't want to deter. You decided you couldn't deter anyone. So it's very concerning because, I would argue, and I didn't listen to what Bronca said here, but I mean, when you have 2 of them concur, and then this guy here, he's saying, well, I'm only concurring in judgment only. I kind of read that as a 3-3 split. Like, I don't know how steadfast Justice Fisher is in his agreeing with this. I mean, it sounds like he likes the outcome, but if he does have different reasoning.
I'm just trying to figure out how you have different reasoning that gets you to this outcome.
I don't know, but when he says he concurs in judgment only, that's his way of saying, I don't like how you guys got here, but good enough. But no, well, if you ever figure out how the Ohio Supreme Court makes the decisions it makes, Runkle, you can make a lot of money. So, they point out here that, and they go through and they make the arguments that this was not an affirmative defense and that he was negating the elements. And they go through it, and they also bitch and moan that they shouldn't have heard the case in the first place. But yeah, this is the big issue here. It's like, I look at this, I'd like to think this is good. And yes, ultimately, this is an issue about jury instructions. But the jury instructions are based on the facts. So with similar facts, you're entitled to similar jury instructions. And so what, ultimately somebody brought this up saying like this is actually about jury instructions. Yes. But the guy fired warning shots, and the warning shots are whether or not he gets a jury instruction. So, yes, Ohio for now, it looks like you may be able to make an argument you could fire warning shots. Would I ever recommend them? No. Would I recommend, like, you're in a car, getting the fuck out of there? Sure. Can you brandish a firearm? Can you say, like, if you want to pull one out and say, do we have a problem? And you want to point it at somebody. I don't know if I can tell you, yes, go ahead and do that. But would I rather you do that than crank off a round? Sure. And like this guy said, he shot, but he didn't shoot at the car. He shot off into the air. That's, I can't advise you to go discharging rounds off into the air either. That's really fucking dangerous. That's really ill-advised.
Yeah, the whole Biden thing of like point a gun out your window and fire 2 shots.
Yeah.
It's like those might land somewhere, dude. Like in somebody's kid. Don't do that.
Yeah.
In general, if Biden has self-defense advice, don't take it.
Yeah. Well, I just in general, I'd be very, very. I cannot because somebody actually has asked me like, well, since that's the case, can I do it? And I said, I wouldn't do it in Clark County because they're going to be really fucking butthurt about this, losing the Supreme Court thumping them. But I would not recommend it if you can avoid it. There's a million ways, de-escalation, deterrence, and
There's
avoidance.
Very few circumstances in which I think a warning shot is called for.
Yes.
And they're always like really niche circumstances such that it's like,
yeah.
Okay.
Very true. Like, yeah, I agree. And this and the whole thing starting over a guy, it's like I said, this is a gas station where like a truck is going like it wasn't like they were going down the highway or going down the road. The truck came too close. Well, until he hits you, he's not actually too close.
Yeah.
That's like bitching in a parking lot, somebody almost hit you. It's like that tends to happen in a parking lot. Did you end up getting hit? No. Well, then go about your fucking day. Like, imagine if this guy just kept his fucking mouth shut.
Well, and Luke Pearson in the comments makes a great comment. Just because you get the instruction doesn't mean the prosecutor can't beat it.
Yeah. Let me see here. They just say, by the way, the Republican that joined the Dems is a Harvard guy. Yes. He's the fanciest lawyer in Ohio. He went to Harvard. When I passed the bar, they had a list of everybody who passes, and then they have what school you came from. And like one guy gone to Harvard, and I'm like, you went to Harvard, and you're back here in Ohio, man. I'm like, you're not doing this right.
Either he really loves Ohio,
yeah,
or else he came dead last at Harvard.
Sure. And here's the thing: just because he gets the instruction, well, more importantly, that doesn't mean the jury's going to accept it.
Yep. Jury could have said, yeah, your self-defense claim is bullshit.
Yeah.
You were escalating this fight, not de-escalating it.
So, you guys are talking about should they use Glock switches. Well, I do have a clip for that though with the kids and their switchies.
Switchy. No talk. No cap. No talk.
There's a clip of these like 13-year-olds and they've all got full auto Glocks, and I'm like, those kids go harder in the Second Amendment paint than I ever will. Because they're just sitting there playing with full auto Glocks, and I'm just like, I'm not that brave. So
we'll have to see, because when my business firearms license comes through, maybe I'll have to get one.
Yeah.
And that'll be fun.
Yeah. So, that is that's kind of it, guys. So yes, in Ohio, can you do this? Like I said, I would not recommend it. You need to be. There's a million different ways I think this could have been done. But yeah, it looks like he's gonna get a second shot at it. I don't know what his trial's gonna look like because that hasn't been set yet. He's gonna get a new attorney because I'm sure he doesn't want the same guy.
Oh God, no.
In fact, I don't think they can give it to him because it's ineffective assistance of counsel. I don't think legally he's going to get the same one.
One of the funniest things I've seen was a lawyer who argued his own, like he argued the appeal and argued that he had been the ineffective counsel at the trial level. And the appellate court is like, we're actually inclined to agree with him, but part of the reason why is
you're here.
You're here arguing the appeal too? How stupid are you, sir?
Was this in Ohio or in Canada?
This is in Canada.
I was about to say, because in America, you can't make that argument if you're taking the appeal, and that's why every once in a while I've seen that where the attorney takes the appeal, and I'm like, I've had clients say, well, can you take my appeal? And I'm like, no, I'm not doing that. I think that's just a bad idea. Anyway, because I'm so wrapped up in, yes, there's no way this could have been wrong, that I don't.
The only time I'll ever take an appeal for a trial I ran is if I'm sure that the issue is not ineffective assistance of counsel or anything like that, and that there's a viable other issue. And I'm going to tell the client, I'm like, listen, I need a second opinion. Like, I'm going to need a second opinion on this one just to make sure I'm not out to lunch. So you need a second opinion. So we're going to get you a second opinion. And if they say it's fine for me to take it, cool. And if they say, no, there's another issue there, then I'm not. And none of them have. None of them said, yeah, Runkle, we think you sucked. But if there's anything where I was like, I shouldn't have asked that question or something like that. No, somebody else can take it. I don't want there to be any hint about that.
I always have, like, I should have done this or should have done that in hindsight. So
yeah, it's just you have those like I could have done better moments, but if you got chewed out by the judge or anything like that, it's like, nah, somebody else can take it. You never want to look like you're making a hurt feelings appeal either.
Yes. And I don't know if you knew this, but Aaron Dean, that cop down in I think in Dallas, he was the one. They were snooping around with their flashlights. And they found the lady with the gun and they shot.
Yeah, through the window there.
Yeah. His appeal got shot down, which I still don't. I honestly, if she had shot first and killed him, I wouldn't have felt like, bro, you guys have picked the side where you guys get to strap up and do this. Like, people should have, if that situation always comes down to it, guess what? The guy in his home minding his own business, I would rather see live every time. I mean, it sucks, but
there's a guy, I think it's Basil Pasiliaris. I'm forgetting the guy's name, but he was acquitted of killing a police officer because the cops came and raided his house, and he ended up shooting the cops when they came in, and he got cleared.
Yeah, well, there's a big case that happened during it was a year or two ago with some black guy. He was accused. He got in a situation where the cops raided the house. He shot back in self-defense, killed the cop. He won on that and the murder charges. He got acquitted, but he ended up getting boned because he's a felon in possession of a firearm.
Yeah, this guy also got gun charges at the end of it. Yeah. So, yeah.
So, but no, real quick while you're here, I kind of want to see this police officer run over this deer real quick.
Oh God.
You guys, and I know there's.
Apparently, the full video is 15 minutes long. They've got like a 3-minute clip, so it probably cuts out the worst of it. But I mean, if you're backing over a deer for 15 minutes, that's yeah.
Oh, I just like accidentally got too far ahead and it paused, and the deer's got its like head up and its ears up, like, "Oh, hello, are you here to help me?" It's like this is not.
Excuse me. Oh, excuse me, officer. I'm so glad to see you. I'm in medical distress. And...
Wait, yes. Wait, it's like, hold on, Bambi. Trust me, you're not the only person who's had that kind of an experience. Oh, you're here to help me. No, you're killing me. Stop. Okay, here you go, guys.
6 months ago. Cell phone video obtained exclusively by Global News showed a Lethbridge police officer repeatedly running over an injured...
It's not... Oh, hold on. Oh, I did a U. I did to you. Hold on.
I
I
do
know,
it way too
sweetheart.
often.
What's that?
I say I do it way too often.
I know, I do it all the time too. Oh my gosh. Oh, this is so sad. The deer picks its head up and everything. You're like, it's not like dead.
We're still not seeing it. It's just a big
No, hold on. I had to switch it over. StreamYard is not fluid at switching panels. It's the one thing I wish they were better at.
All right, now we're seeing something.
Decision Wednesday on a case that sparked public outcry nearly 6 months ago. Cell phone video obtained exclusively by Global News showed a Lethbridge police officer repeatedly running over.
Look, the deer's got its head up like, oh, hello. What's so cute?
For an injured deer for the purpose of euthanizing the suffering animal. The incident was examined by ACERT as well as the Alberta Fish and Wildlife Enforcement Branch and the Alberta SPCA, and it was found that the officer acted reasonably.
The issue is what options did he?
That's reasonable? Brutally torturing an animal?
Now you got to keep in mind, the police reviews here basically just say it's always reasonable.
I'm sure he could have beat it. He could have thrown rocks at it and they would have been like, well, he didn't use the car, so that saved greenhouse emissions.
He just goes out there with his boot and just like,
yeah.
But,
he have, and did he reasonably consider those options? And he did. And that's the expectation that is on him.
Following the January 5th incident, many questioned the officer's decision not to use his firearm. ACERT saying Wednesday that given the proximity to homes and traffic, the possibility of a ricochet was too great to justify the risk.
A cement roadway with a cement median with the deer's head at an angle over the median. So the firearm was not the option in this case.
The officer's failure to reach out for instruction was also questioned.
So does the officer spend an hour trying to track people down or get advice while the deer is lying on the roadway suffering? How long is too long?
Officials acknowledging the emotional investment of the public in this case, particularly when it comes to the video.
The emotional impact of the video cannot be understated. It was and remains profoundly distressing and heartbreaking to watch. It is unforgettable and impossible to unsee.
I appreciate again that people have, been a bit emotional about this, and they're.
Yeah. That's a nice Canadian guy. I just want to say, my name's Jay. I just want to say sorry. That's out by you, right, Lethbridge?
No, that's a fair bit south.
Oh, okay.
Well, I mean, it's the same.
Alberta,
it's the same.
Okay.
Yeah, it is Alberta.
Okay.
People that are passionate about this, and I think I would encourage everyone essentially to move on responsibly and be considerate in their reaction to the findings today.
A sentiment shared by Lethbridge's chief of police, who addressed ACERT's decision Wednesday evening.
I can't operate on an emotional response. The officer, there was no criminal charges, there was no charges laid today. And so because people have an emotional reaction does not equate to his dismissal.
The name of the LPS officer has not been released. Danica Ferris, Global News.
Oh, darn, we can't see it. All right, well. I thought
so,
we were gonna see, that's still rough.
Now keep in mind, this is also the same police detachment that arrested a woman dressed in a stormtrooper outfit.
Oh, this is
because
them?
She was outside of a store called the Galactic Cantina with the Star Wars symbol on it. So Cocoa Vanilla Galactic Cantina, which has all sorts of Star Wars themes.
Yeah.
Somebody called in to say there's a person with a gun. They show up, they find a stormtrooper with like a obvious
fake blaster,
a fake blaster, and they do like this
video.
full crazy takedown.
Mm-hmm.
Like, I'm just saying, stay out of Lethbridge, guys. Like, it's probably a good thing that they didn't decide to euthanize her by running her over.
Yeah.
So, Oh, no charges laid in that one either.
Yes. Well, I'm sure that, as I like to say, they use the John Coffey defense. Like, we just simple police folk. You done tell us what we do. We's do it. We can't be expected to think for ourselves. They're simple folk. And yes, get Alec Baldwin to help out. And he saved Helena from dying of cancer, don't you know? Yeah.
Oh, jeez.
Yeah, what fate Helena Hutchins may have suffered, Alec Baldwin spared her. Yes, Alec Baldwin spared her the trauma of knowing that Russia invaded Ukraine. So actually he should be very thankful.
I was like, what was the timeline? I guess, yeah.
Yeah.
Huh.
Yeah, it was.
I feel like afterwards there might have been a little bit more.
Well, and then Wagner sent him a letter saying, "Hey, we read you like killing Ukrainians, so
come on down."
Yes. If I was a Russian and Wagner, I would have done that. I would have done a video where it's like, Alec Baldwin, we wish for you to join us.
Or just like we celebrate the achievements of Alec Baldwin.
Yes. I so would have done that if I
just because it would have made him lose his mind.
It would have been great. Yeah. Well, I still think they should have Trump do a Alec Baldwin acting as Trump skit at some point.
Oh God, they
Zero
he
fucks
would...
says Buck Lives Matter.
Oh jeez.
Well, except that Buck was broken.
They absolutely would have lost their oh man. But Baldwin
he's saying
could walk.
she actually did have a tumor at the time of that death.
Huh.
Oh, she really was sick. Oh. Yeah, well, the problem with that is you can't say, she was gonna die anyway because you took what little life she would have had left, even if it's a second.
Even if it was 5 minutes or whatever.
Even 30 seconds, even if 1 second more of life.
Yeah.
You've taken that from them when they were
You see somebody and it's going beep, 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 and you just come in with a hatchet. It's like, nope. Yeah.
Or popping the plug that half a second before. Yeah, it's like, you gotta wait till it's done.
Yeah, it's the same thing with you get. I don't know why Bowles was going into that big thing about hey, they got bad medical attention because it's like, if you shoot somebody, and the bad medical attention, you still have a problem because you put them in that situation.
Well, and there are times where it would matter, like if he had shot her in the foot, and
or if he'd shot her with a Nerf dart or something, and they get a medic to just check because it bounced off her eye, and she's like, it's really itchy. Can you look at it? And they inject her with something that kills her.
Yeah,
then you've got a foreseeability problem. But there is no foreseeability problem from was shot with a gun.
Yes, and at that point, trying to intubate her and do all of that, it's very common for that to happen anyway. It wasn't a random occurrence, and
although
they're trying to.
They did screw it up even despite that.
Well, yeah, they did, but I mean, she's drowning in her own blood. It's a mess. Absent them, I kind of get the feeling because I've talked to a doctor or two. Unless they unless that would have happened in the parking lot, she probably dies.
Yeah,
pretty much every time.
It's basically unless you walk into the ER ward and shoot her there.
Yeah.
So
yeah. So Josh for $5 says YouTube keeps blocking my inappropriate comment about warning shots on your face. So here's some money instead. Well, thank you. I'm sorry you couldn't post it. I'm very sorry. Too bad. Yes, maybe YouTube in an older day, in another age, would have allowed it. Excite Under saying Baldwin needs to see a trial like Hannah Reid will. Based on I have to read the whole thing, and we might go over that on Monday. Well, not on Monday night. It'll probably be Tuesday night.
I'm almost certainly going over it in my Monday night show. So
there's a lot. I've read through parts of it. Ooh, apparently they screwed up a lot. I don't know enough to get him out of it, but
I think dismissal is 30%. Because dismissal is always a tough sell.
Yeah.
And the thing is 30% is better than when I saw that they're making a motion to dismiss, my starting point was negative 25.
Yeah.
It's just and they do a lot of digging up from that. I don't think they're going to get it thrown out just because it's such a high profile case. I don't think the judge is going to want to do that. but I think they're doing. I think partially it's PR because they're worried. It's very clear they're worried about the press on this one, but also it's a big issue there. So I don't think they're going to get it tossed. Now, Luke, I'm going to differentiate yes about the expert armor said exactly the opposite, which is interesting. But the other thing is I don't know what Bowles, because a lot of their issue on this one is what things were raised. Because apparently in New Mexico, you've got a right to have the grand jury notified.
Yes, it's called an alert letter. Yeah.
Yep. And
we don't have that.
Yeah, that's not everywhere, certainly.
No.
I was like, I've been spending a bunch of my time sick, like reading over some of that, going, holy crap, New Mexico, good job.
Yes.
And like the person under investigation actually has a right to testify in New Mexico if they want. I mean, you probably shouldn't, but
no, but you can at least, instead of testifying, you can at least put on the record a bunch of evidence through your attorney.
Yeah. And I was like, okay, that's really cool. But I don't know if Bowles did that stuff. That's going to be what's that?
I doubt he did.
That's the Luke Pearson had the comment of if Hannah didn't have that grand jury testimony, she gets herself a new trial. So it's important to her too.
If he didn't do it though, I think that's more of a if you didn't do it, it's like you're waiving the right to it.
Yeah. If he just I don't know. I don't know.
It sounds like in Baldwin's case, they didn't have they were denied like they wanted to, but it sounds like the state kind of played fast and loose with the grand jury, so they didn't get a chance to do it. Which is different.
Luke Pearson makes a good point. I mean, for trial, Bowles didn't need to ask for the exculpatory evidence to be entitled to it. So he's saying that he should have been given the grand jury proceedings. I don't know. Is there a requirement to provide a transcript of that?
I don't know about in New Mexico, but if I ask for the grand jury transcript here in Ohio, that's going to be. I could get it, but I would need a hell of a reason for it.
I think that the thing is I certainly would have asked for it.
I would too.
Because I think Luke Pearson makes an excellent point that this is potentially a. Now, this is not the issue that has been raised at all by
but this is
Bowles,
on an appeal or post-conviction motion. Yeah, this is newly discovered evidence that apparently we're now learning.
The problem is it newly discovered evidence that could not have otherwise been obtained?
Well, how would I... Well, because you can't just ask for all the transcripts ahead of time, making sure, hey, I want to make sure nobody says contradictory statements.
Yeah, but you know that anytime somebody testifies more than once, there's contradictory statements.
Sure. Well, and it's one thing to say, like, red shoes versus blue shoes, but yeah, this totally could have happened to say, this totally never could have happened. I also heard, though, apparently the FBI expert also may have gave different testimony at the grand jury as well.
And if that's the case, then...
Which, if that's the case, he committed perjury, which... isn't rare for a Fed, because either the gun could go off on its own or it couldn't go off on its own. And he said it was impossible.
Yeah, and that is a real concern. Because, although, I didn't like some of the stuff, because some of the arguments in closing that were made by Ms. Morrissey seemed to be ones that were very favorable to Baldwin. For instance, her whole line of argumentation in closing of like, you gave the gun to Baldwin and you knew he would manipulate it. Yeah. Like, and that was obvious that he would manipulate it. I'm like, that says that Baldwin should walk, right?
Yeah, but that's not as big a deal, I think, because you can make, who was the shooter? If you think two guys did it, you can say, multiple You know, you could say in this case, well, yeah, he probably did. You can say in this one, yeah, he probably like. I think you could make an argument that they both could have been involved here, but apparently though, um, yeah, it sounds like if there is conflicting testimonies here, but yes. So Lucian Haig, the son testified at the grand jury, the dad testified at Hannah's trial. Okay,
Interesting.
yeah, yes, I am curious to know then what the son said. And if Bowles was smart, he would do that, but I'm assuming Bowles is not doing any of that, and he's using the Esmeralda to like do a gypsy curse on the office to keep the spirits out.
I mean, the thing I'm really torn at is I don't like Hannah. I don't like what
Yes.
she's done, in terms of her carelessness. I don't like what
Mhm.
she's done to the industry.
Mm-hmm.
I think she deserved a better trial than that, and she deserved certainly a lawyer who didn't like walk her into the fucking police station to any of that, right? So, like, I think she could have walked if she had a better lawyer. And
I think if she only had the first interview, she might have stood a chance of walking.
well, the whole argument that Bowles made in his close of like, well, she gave that interview, but this was right after the incident. She was stressed. She was, whatever. She was unable to, like,
Yeah.
And I'm going, this is a great argument for why she might have said some stupid things in the interview immediately after the shooting.
Yes.
And it's an absolute dog shit argument for all of the stuff while you were sitting next to her. So,
yeah.
do you see how much you tanked her?
Yeah. Yes. And then Joe Loy for £5 sterling. Apparently, though, from Joe, it's not the King sterling. I earned it. Great chat. Well, thank you, Joe. And I will say, yes, it is Joe's sterling, not the King's sterling today.
The King can't have it.
Well, it's not the King's shilling this time. To quote Sharp, the King could have his shilling back. Without the second interview, you do have a very weakened argument. And yes, very much. It's one of these deals. Hannah doesn't talk to the police at all. Guess what happens? I think she walks. Or there's at least a lot of things you can, but there's still the
Luke,
issue of her with the
I think
the
Luke is
hammer.
saying that you'd need to get that there wouldn't be the additional argument about like she wasn't allowed in from COVID and so forth.
Yeah.
But you could get that in through other witnesses, assuming it's
Yeah.
true. Like assuming you could find other witnesses to
Or you
back
could
it up.
have
you
Hannah
could get
say
that
it.
in.
You could have Hannah make the statement later.
And the other thing is, Hannah would have been in a much better position to testify.
Yes.
Without that second interview.
Mm-hmm.
And I think it might have been a different case if she had been. The problem is that having given 2 interviews, her testifying was extremely risky. So, yeah.
So, no, I agree. That was the problem. But she could have, if she hadn't said anything, she could have gone up there. And at that point, Carrie Morrissey treats her like shit. Carrie Morrissey looks like the bad guy. I think so. She had a lot going in her favor. But yes, had she not talked. And for Alec Baldwin, he talked to the cops once, but then he goes out on TV and does that whole thing with George Stephanopoulos. And it's funny because that was like the second video I did on this channel. I was just like, he needs to shut up.
If he didn't talk, I don't think he'd even be charged. Because just if he kept his mouth shut, it would have been so hard for them to get to things like how, does he even know that it's a bad thing to pull the trigger? Like, does he know anything at all? So, yeah.
Well, and Luke, you're saying, well, how does it get in with Hall saying he would disprove the COVID stuff? Well, you've already pled out. You're trying to cover your ass. You're here to testify to save yourself. You got a misdemeanor deal. You're going to say COVID wasn't a fault? You're telling me COVID wasn't a problem in 2021 with all you Californians? The New Mexico, like these New Mexicans, like they've had to deal with the movie crews coming in or out. And they're going to say these spaz Californians, like I think they would have been able to make the decision, believe Hannah or not believe her.
The thing is the bike accident bit, if you walk her through it and you prep her for testimony, you get her to avoid the bike accident as a problem at all, because the prosecution said that they would only bring it in if it came up, which means basically you have to prevent her from saying anything along the lines of "I would never lie to a cop."
Yeah.
And
because New Mexico limits the scope across, so yeah, you're safe.
And go ahead.
Say, like in some states, like here in Ohio, cross is open in scope. So Kerry could have immediately come out and said, "Isn't it true you lie to police?" Like they could have gone immediately down that road. But in New Mexico, where these states have the old structured rules, yes, you would have told Hannah, "Don't mention the damn cops. Don't mention I don't lie. Just say I thought I did everything right."
And the other thing about how else do you dispute the COVID, and making a comment about if Bowles is actually a decent lawyer in the second interview, you can get that statement while also not sinking yourself. The problem is that if she doesn't sink herself at all in the second interview, then prosecution just doesn't play it. And it doesn't get to the jury unless you testify, because the prosecution just says, we're not tendering this because we don't think it has any admissions against Hannah's own interest.
Yes.
And so then it's hearsay unless Hannah gets up on the stand and says it herself.
And if the prosecutor's not going to offer it, you can say, you talked to the cops a second time, didn't you, Hannah? Yep. And you just leave it, because that's not hearsay. And you point out later on, ladies and gentlemen, she came and gave a second interview. You never saw it. Why didn't you see it? Is it because everything Hannah said was corroborated? And then that's when the state can't say, well, we didn't show it to you because of this, that, and the other. You know, they're going to be limited in what they can say.
Yeah.
Because if they try to claim, oh, well, here's what she would have said, you're like, objection, that's not an evidence. And you just point out the state's not showing you everything. Why aren't they showing everything? Because it hurts their case. And I think she could have done that stuff, but
it's tough. I mean, the problem is Bowles gave that second interview before he even knew what the case looked like, is the other problem. Because you can see the moment when he learns new shit about the case.
Yeah.
And doesn't do the thing which he should have done, which is, even if he had a strategy for that interview, once you learn new shit, it's, we gotta go. Oh, look at the time. We've got an appointment at not here.
Yes.
Hannah's got to get her hair cut.
Yeah, once you learn the cops are not playing into the strategy you've set up. They moved on. You're trying to play like you're standing there in the middle of the 50-yard line getting ready to play football, and you find out the cops are next door playing baseball. Okay, well, I guess we'll come back another day. Yeah, that's your signal. The enemy's the plan's not working.
It's very clear they seem to have had a thought of there was a single round planted as sabotage or something like that. And then once they heard that there were rounds all over the place, they're like, what? Like, get out.
Yeah. Oh, and because Luke is from New Zealand, this I thought was very scary to see. But this is the Prime Minister from New Zealand.
Oh, God. I can see the comparison already in my head.
Yeah, he looks very damn close to Bowles.
Holy shit.
Yeah.
Like, if those two got on an elevator, they could just trade lives and nobody would know.
You could have pulled a Saul Goodman at the beginning. Well, who robbed you, sir? Oh, no, that's just the Prime Minister.
Which one is the real lawyer?
Yes. Oh, no, this gentleman in the back, the Prime Minister of New Zealand, he's just stopping through. That would be hilarious if that was your, like, witness to try to, your plant in the audience to throw off the witness. You're like, oh, no, that's the Prime Minister of New Zealand. Have a good one. Judge is going to be like, you know, Mr. Martin, don't lie and say it's the Prime Minister of New Zealand. It's like, no, really, it is.
It's actually funny because my ethics class covered the Saul Goodman maneuver there.
Yeah.
And how you can do it ethically in a Canadian court.
And do you have to notify the court that you're doing it?
You have to notify the court that you're doing it. And the other problem is it is insanely risky. It is almost never worth it.
Well, the only and like you say, you have to notify the prosecutor that you're doing it, and
Everybody's got to be notified, so everyone's got to be aware.
And that's where if you're like the only other way around it is you do like a double. You do the irrationality move, where you actually keep your client at the table, because then you can find out if the prosecutor talked to his client or talked to the witness, and the witness says no, that's not him. It's like actually that is him. But then it's like super irrationality. But that's what you think I'm gonna do, so I'm gonna do.
What you need is like 3 giant cups that you could put over, shuffle them around.
Yes. So, but no, that's kind of it for me tonight. So you're looking Monday night. You're getting ready for gonna look at the Baldwin dismissal.
Yeah.
What else you got going there?
Did you hear about the Toronto police and how they advised people to keep their car keys by the door?
Yes, so they don't
to
come into
make
the
it
house.
easier to for home invaders.
Yes.
So I'm going to talk about that. They've already backed away from that advice, but yeah.
What did they say now?
Now they've said we don't really recommend. Like, it was well-intentioned advice, but it's not the advice we would give. And I'm like, you don't say. There's some more sob sit. Oh,
they
sorry.
Say can't kill them. Certainly, they're not going to say that.
I mean, yeah. I'm just like, because they're saying, oh, people are coming through, kicking down doors with guns and whatever else, and I'm like, okay.
There is a reasonable answer for that.
Yeah, if I like. At this point, I'm just sitting here thinking, hey, if I hear that the police are saying guys are kicking down doors with guns, I'm like, okay, somebody's kicking down my door. I'm getting strapped in a hurry. Although Canada does make that hard, but there are ways to do it. Maybe I should have a video on that, except we've got Trudeau, who would probably turn around and ban all of those methods. So, and Luke, I do mean to look into the Delphi stuff. I haven't
Holy
had time.
cow. I can read you in on a little bit, Runkle, when you get a second. Not right now, but I can read you in on a little bit. It's you basically we're now at the point where it's clear that there were multiple suspects. The police really didn't investigate them. They've lied about the experts because they consulted an expert saying, well, does this look like it was a bunch of runes? And the expert said, yeah, it looks like somebody who doesn't know what they're doing, like what somebody who claims they're a pagan would think, and that's not how real runes and paganism work. So when the defense said, hey, what's the name of this expert? The police officers are like, well, we forget his name and we didn't write it down.
Oh shit.
And it made it into the news, and the professor was like, oh, hey, that's me over here. And they found the professor, and he gave him his copy of the notes, and his notes are completely different than what this officer took down.
Oh, wow.
This officer has a habit of doing that. Like, all of a sudden, he's found like a bunch more notes from when the murder happened in 2017 of interviews he gave. Oh yeah, here's some more interviews. And like, there's still, the state has like Brady violations out the wazoo. And this is the one where the judge kicked the attorneys off the case. And then it went up to the Supreme Court of Indiana, and they said, you actually can't do that, Judge. And the Supreme Court of Indiana put them back on the case. Oh, and it's so bad. There's so many problems. And the judge is actually going to be having a sanctions hearing on the 18th, but it's we're not going to get to watch it because she denied all press coverage.
Sanctions against who?
The defense attorneys.
You know, if I had unsuccessfully tried to kick 2 defense lawyers off a trial,
yes,
I could tell you those defense lawyers could probably, like, if I'm the judge and I've been told that these defense lawyers, I can't kick them off.
Yeah.
That's probably the point where they could like literally climb up onto the judge's desk and take a shit. And I would still be like, okay, that's not contempt today for reasons.
But this is the prosecutor filing it, and they got reinstated back in the beginning of January. The day after the Supreme Court reinstated them, he filed this motion for contempt and sanctions. And
Yeah,
the
if I'm that
sanctions and
judge-
contempt, well, the sanctions and contempt are for things that happened like over a year and a half earlier. And
If I'm the
just,
judge, I'm just at that point. I'm probably just saying, you know what? Somebody's got to get kicked off this file.
well,
It's me. Goodbye.
Well, no, she doesn't want to leave. This woman is insane. So like the defense put together like a 300-page of these, like it's called a Franks motion because it's a U.S. Supreme Court case of the police misconduct and the actions of the state and all these problems that are going on. The judge says, "Yeah, after taking it all under advisement, it's denied." And she wrote just a quick entry in the online docket. She doesn't put any reasoning out there. She just says denied. And from what we found out, she's a judge from a neighboring county. Attorneys in the county are like, yeah, that's what she always does. She never grants motions. She just says nope, and that's it. It's a very scumbag judge.
Wow.
Yeah, Francis Gull, good old Frankie. And it's also getting bad now because there are true crime-itis is taking over. There are a lot of true, and it's sad because there's a lot of true crime people involved who are just absolute state bootlickers. And they are like, they're now sending in their things like, your dear Judge Gull, I've got proof that the defense is working with these other true crimers and they're bad people. And I covered one of the guy's letters he sent into the court, and it was just garbage. And apparently the guy lost his shit later that night after I'd done my thing on Thursday or Wednesday. And another one of the guys who he's like, well, I'm a process engineer, and we're going to use our deduction, and we're going to use our logic skills, and we're getting to the bottom of these things. That guy nuked his channel, too, after I highlighted it. But, yeah, there's so many of them that are just it's bad. Everybody's coming out of the walls.
I find that there's some really good true crime channels, but there's also a lot of them that are either the government is always right 100% of the time, whatever, or B, the government is never right, and there's going to be some sort of conspiracy as to why. And so I end up watching some of these channels, and I'm just like, if you're never right with your predictions, why do people keep watching you?
Yeah. Well, and of the things to be, I'd rather you. I think it's far better to be on the government is always corrupt than the government never does wrong. I think they're both bad, but
it's good to be skeptical.
Yes.
But you've got to be skeptical in ways that make sense.
Oh, I agree.
Like, hey, maybe this officer is lying versus like, hey, maybe this officer is a secret member of a cult and, is actually a serial killer connected to this dozen other crimes, including ones before they were born.
Yes.
Like,
yeah. And well, there's one that I watched a couple of times, and when they were talking about these attorneys, they're like, well, I don't know if this one's dirty or that one's dirty. We don't know about all their stuff. And I said, how about we just assume that this is not a Netflix show where everyone's crooked and there's some sort of like season 2 coming along where you're the main character in all this and you're cracking it all open. It's like season 3 is where you take down the governor and you find out he's corrupt too. But then it's season 4 and you find out about the senator who was playing the strings all along.
I mean, somebody's like, it does feel like a lot of the true crime. And again, there's some really good people who aren't into this, but there's a bunch of people who really think they're the main character in these stories. And it's like, you're not.
Yeah.
And you got to be careful if you start injecting yourself into it. So, like
I'm involved in a true crime situation right now where I'm representing somebody.
I was like, who'd you kill?
Well, no. They're not. It's dealing with the true crime running amok, and I'm hoping this person now doing all this nonsense just got indicted by the county government for doing a bunch of insane things. And I think finally, once the smoke is cleared, I'm hoping I can tell the story because when you listen to it, it sounds Like it's almost like if it didn't involve somebody being dead and missing for years and years on end, and a family that's been utterly destroyed, hoping their loved one was still alive, it would be a comedy of how this person has acted. But it's really fucking sad, and I'm hoping at the end of this I can talk about it. So, but yeah, that's part of my issue with the true crime thing. It's like I'm actually dealing with like watching it all unfold for a client. And I'm like, it's sad.
And the thing is like you get these true crime people who are like, I'm going to start sending my theories to the cops. And it's like,
yeah,
unless you actually have evidence of something,
yeah,
cops don't need your theories. And, you actually run the risk of getting, I forget the name of the case. Well, there's a U.S. case where somebody, like, it was on the news, and some, like, busybody sent in a bunch of theories.
Yeah.
And what ended up happening is that these theories, they sent in, like, hundreds of them, and they'd get opened up by some functionary idiot at the, like, front desk, and everything that was clearly wrong would get thrown into the trash can. And everything that was accurate, they'd set aside for further investigation. And so they threw out like 97 letters from this person and then kept like 6 that were accurate. And if those are the only 6 letters you see, what the police saw was basically this person is sending us letters and they have all of these details from this crime that have never been released to the public. And that person got arrested and like massive investigation until it was like, I don't know, this person is just trying to introduce themselves into this case and good job, you did it.
Yeah.
I see people, nope, trash isn't an option. They were throwing out the ones that were just like obviously wrong, right?
Yeah.
So, yeah.
Trash is not an option. Like that's you're gonna see, like they'll do whatever, and then all it takes is a cop or two is dishonest. If they want to, and in this Delphi case, there's a bunch of dishonest police.
I had a file where the cop wrote down everything he says the guy said to him, which was really funny because when my client got his cell phone out of property, he had set his cell phone to record. And so his cell phone recorded that conversation verbatim, and it did not match the officer's notes at all.
I'm sure that was just a simple mistake by the officer. He tried.
He was listening real hard, and, just things like when the guy said, I don't know what you're talking about, he wrote down, yeah, I probably did that. Stuff like that.
Is he still a cop?
Oh, of course.
I was gonna say that's the only thing that matters. Is he? And he's still out there.
They're always still out there.
Yeah.
So.
Yeah, they never go away. But yeah, I will be happy to read you up on Delphi, and give you kind of like the. I'll try to use one of Robert Gavea's mind maps because otherwise it sounds very, very crazy.
That's the problem I initially had was I was trying to look into it and I'm like, I don't know if this is just the weirdest case ever, or if I'm like reading somebody's like conspiracy, like bits of string across the room kind of thing. And I'm like, yeah.
No. And there's like Odinist involved and like pagan sacrifice. There's all kinds of things that have happened. There's tool mark analysis. It's got everything. It's got it all.
I need to find the time. What I really need to do is like sometime figure out a way to make the jump from like, lawyer to primarily YouTube. But I want to go and actually make the like a set of here is the forensic analysis set of a test and just be like, okay, we're going to send this to some people, and if they can pass this test, then they get 50 grand. And hey, tool mark, ballistic tool mark analysts, do you want some money? Because there's a bunch of defense lawyers who said that they were willing to put up substantial cash on this one. And it's like, we'll we'll just make this into a contest because I'm betting that their odds are actually not good.
Well, this case, because in this case of these two girls, they were like 13-year-olds, found dead in the woods. There's like a 40 cal round laying on the ground. And this guy who's currently in jail, Richard Allen, has made this really nasty habit of, oh yeah, the police, like, yeah, I talked to the police. Yeah, hey, I was in the woods near there that day. Okay. And then after a while, they come back to him a couple years later. And they're like, hey, do you have a 40 cal pistol? Yup, yes, I do. And they go get a warrant. And he's got a SIG 226 and 40 cal. And the tool mark examiner's like, well, it's consistent with coming from this type of firearm. And it's like, it's all machine tooling. I'm sure every other gun on that line is going to produce the same ejection markings. Because this wasn't one where they haven't commented that there was an artifact. Yeah.
Like consistent with just means not excluded.
Yes.
So how many
other pistols could that have come out of? I don't know.
Well, I mean, to pick a really ridiculous example, I am drinking from a can of Coke. This is consistent with Sean having murdered 20 people because it in no way disproves that.
Yes.
This doesn't mean that Sean should go to jail. It just means that consistent doesn't mean.
Yes.
So.
Yes. What is it? It's what would make it inconsistent? If it was inconsistent, what would that mean? And no, and I agree with the tool marking. Like, there are times where I do think a tool marking analysis could prove something. Like, let's say a guy got stabbed with a knife and it's missing a chunk out of the blade, and that chunk fits perfectly, like that dent in a dead guy's skull. But when it's something like that, you don't need an expert because the jury could sit there and go, huh, these match up. Yes, this probably was the murder weapon. Oh, somebody's saying it's Dr. Pepper. But do you get what I'm saying, Runkle?
Oh, yeah.
Like, the times where it's clear, you don't need the tool mark expert because the jury could probably figure it out.
And the other thing is, there is tool mark analysis is much better at exclusion than it is at inclusion. So you can say, we are sure that this stab wound was not caused by this knife, right? It's the wrong length, it's the wrong size, it's the wrong anything, it's the wrong whatever. Okay, cool. But if you do find one where the stab wound is, yay deep and yay wide and whatever else, well, how common is this particular knife?
Yeah,
how common is a knife just like it? We don't know. And so what that tells you is you've excluded some unknown percentage of knives out there.
Yes.
I mean, hell, this knife is a handmade custom knife. Well, not custom. It's a handmade knife from a knife maker.
Yeah. Only one like it.
Except that it's probably not.
Yes.
Because even though it's like a custom, or even though it's a handmade knife, I'm betting there's lots of knives with very similar.
Well, yes. Well, from that guy, that's the only knife he made. Yes. And what you could say is, okay, I've clarified that specific knife is not the knife in question out of every knife ever made. That's possible. Yeah. And how many knives are in Edmonton, Alberta right now? A gajillion.
And it's even worse with the issue of manufacturing, because all of these, if this was a mass manufactured knife, then there's who knows how many.
Well, that guy had a SIG 226. How many SIG 226s and 40 cal were made? How many of them are in the state of Indiana? A ton.
Yep. I mean, I've got a 226. It's not in 40 cal, but I've got a 226.
And I'm betting it would give similar. It's going to give similar tool marks.
I'm betting if I recalibrate it.
Don't send it into the Indiana State Police.
Oh God, I mean,
yeah.
Some of these things, you get these experts who say that they can absolutely definitively tell X, and then later when they've actually tested them, they are 0% good at it. So, like, bite mark analysis, which turned out to be just god awful. Hair and fiber analysis, which turned out to we really need better scientific analysis on all of this. So
well, the problem is there isn't better analysis. Like the FBI, its hair analysis unit, they've admitted like, yeah, we're actually not real, like we kind of made up all this stuff. And now we're seeing, like, in Colorado, one of their top forensics person. It's like, yeah, she may have altered like 30 years worth of results. And the thing is, it's not her own. It's not the first state crime lab with that evidence scandal. It's now one of how many?
Like all of them.
Yes. Yeah. Yeah. And they acknowledge that. And the thing was, for like the FBI, their hair forensic unit. Their elite forensic unit gave flawed testimony in almost all trials, which they offered hair comparison evidence over a 20-year period. So it's like, but nowadays all you have to do is say my DNA. Judge is like, okay, it's good. You can't say, are you sure?
Yeah, and
because they're like, it's science.
And the other problem is juries and judges don't necessarily understand the significance of DNA.
Yes.
Like, hey, let's say you find this pop can at a murder scene. Does it mean I committed the murder, or does it mean, like, maybe I chucked a can out a window and it landed there, or maybe I was carting a bag full of cans and it fell out, or maybe maybe a homeless guy was, picking up
someone
cans.
planted it there. Any number of things. Yeah.
I mean, hell, we're going to see a lot more cases of planted DNA. And can you imagine how much that would suck? You're sitting there, you're like, they got your DNA at the crime scene. How do you explain that? It's like, I don't. Like, what do you do?
Well, that's the thing, because if you say, oh, it's planted, I mean, everybody sitting on that jury is going to be like, oh, bullshit.
Yeah.
And that's the thing, though, because it's really hard to say, like, if you were sitting there, is it, like, how likely are you to say, like, well, that's possible, but not likely? I mean, Let's
say the Kohberger case. Let's say you really wanted to murder a bunch of, college students. And so you throw on some gloves, but you steal somebody else's knife. And it's got their DNA all over it. But you make sure you don't get any of yours on it. And then you just make sure to leave that behind.
Well, no, I agree.
Who's going to believe that?
That's
right?
the hard... But yeah, that's the biggest thing that's screwing Brian Kohberger right now, is that knife sheath with the little button where it's got the DNA on the snap, and it's like, uh-oh.
But, I mean, that one I'm like, there's a lot I don't get. Like,
why did he pick these people?
And why is there zero DNA in his car?
Yeah, why didn't they find... Yeah, why is there no set of bloody clothes found somewhere?
I mean, even if he changes, how does he manage to get zero of their DNA in his car if he's driving out of there?
Exactly.
I'm like, it's really, really hard to do that. And somebody says he obviously cleaned his car. You know how difficult it is to clean a car that thoroughly?
Well, here's the thing. Even if you do it thoroughly, I just covered a case, Michelle Troconis, up in Connecticut. And husband kills wife, chops up her body, disposes of it all over town. The truck he used had blood all over the interior. They switched out the seats of the car. They did a little bit of scrubbing to wipe up the blood. Then they got the car detailed. That actually was able to stop them from doing, they did the luminol test, the KM test on it. The car lit up, but they couldn't tell it was blood because the samples were contaminated.
And that's probably helpful in the sense that I'm guessing the cleaning chemicals also reacted to the luminol, so everything.
Well, no, because it was still clearly like there were drops and drizzles all over the car, so it wasn't like the whole panel glowed.
Gotcha.
Like, there was still, you could tell there was blood in there. But it didn't help. There was enough of other issues though. Like, the guy admitted, like, because the guy runs a company. He borrowed his employee's truck. The employee said, "Yeah, when it came back, it was covered in blood, and I switched the seats out." Like, he admits that happened. There was a bunch of other evidence that tied the guy to the murder, and then that tied Michelle to it as well. But yeah, it's really, like, I've mentioned this before. When you commit a crime, you've got to be like, 100%. There is, like, the little bit you forget, that's it.
They only need to get lucky once.
Just
and sometimes, like, you could be perfect. Like, let's say, and they find a tiny speck of like the victim's blood in his apartment.
Yep.
That's it. That's game. Right?
And for Brian Koberger, the idea that he didn't get any blood anywhere on him, or he cleaned it all off, or the clothes he used were completely... Yeah, the odds of him getting that all done, because in this case that I'm talking about, they dumped everything all over town. The police were only able to find a bag of bloody clothes at the end of the day. Everything else was gone. They can't find the body. The woman's been gone for 5 years. But they found a bag, and one of the bags, they found they found her fingerprint on it, on the inside of it. And they found a bloody shirt, a bloody bra. But they were so compromised you couldn't tell what was on them. And everybody, like, there were pictures of her wearing the dead woman wearing those clothes, and it's like, and then there's pictures of her, like, it was all circumstantial, but yeah, it just, that little bit, it doesn't.
Luke Pearson does make a good point about, or have perjuring racists find all your mistakes.
All right, we're talking about OJ. Yes. Yes.
I mean, if OJ did it, he got tremendously lucky. The thing is,
he did. Well, he also had just cops who did weird shit, like the thing about
the missing blood.
Well, but they also took evidence home. It's like, do you ever do that? He's like, no, I've never done that ever before. Like, people doing weird and stupid things is enough.
My suspicion on that one is that the cops were really sure, really sure that it was OJ, and they're just like, we're just gonna push our finger on the scale.
Yeah.
Just a little bit, and and they blew the whole case up.
Yeah. But I still think it was OJ's son was involved. And I think that explains why OJ has the cut on his hand.
That's also one of the few people, like, whenever you have that question of, like, somebody else involved, it's like, why wouldn't, wouldn't you point the finger?
And for people asking, OJ had an adult son, not like, it wasn't like his 12-year-old son with Nicole. He had an older child. So it wasn't like the 12-year-old walks up and starts stabbing his mom to death. This would have been OJ's original marriage, the son from that. So Nicole would have been his stepmom.
And like, kid kills stepmom, that never... Nobody's ever heard of that.
Stepmom who steals all of dad's money and is out running around with the, I forget what the hell Ron Goldman did where Nicole knew him, but yeah. So, Hella is saying, do you know about the Zachariah Anderson case?
A little bit.
Yeah. So,
I got to do some more follow-up on that one.
Yeah.
I feel real bad over that one because the bits I've heard are just like,
oh yeah, me too.
Horrifying.
Me too. So, yes, guys, well, Ron Goldman was a waiter, but when he wasn't just a waiter though. Like, he wasn't just coming by to, say like, oh, you dropped your keys, ma'am, when he got found at the house. Like, there's a little bit there. Where's the thing here? Yes, Johnny Cochran probably did tell OJ to do that, but hey, that's
prosecution didn't need to tell him to put the gloves on.
Yeah, they didn't, or they should have made sure they fit beforehand. You don't do experiments for the first time ever.
You don't do the rule. They always say don't ask a question if you don't know the answer. Yeah. The rule really is don't ask a question if the answer could hurt you.
Yeah.
And they bet their entire case on that. They
Yeah.
bet their entire case on it.
Mm-hmm.
And it's such a stupid thing to bet your case on, because even just like, flexing your thumb or something to make it like,
Yeah.
yeah.
Yeah, no, that was they totally got him. Have you ever watched the American Crime Story version of that, this miniseries?
I have not.
You really should, because it's actually, because I've read a couple of the books. It's actually very well done, and usually those FX things are not good, but this one was done very, very well. You'd enjoy it. You'd enjoy it, especially the way they had everybody, like the people they had who they had play. It was actually very well casted too. It's got Cuba Gooding Jr.'s OJ. So
And yeah, misanthropic anthropoid saying he was wearing latex gloves. He was. What
Yes, he
makes
was.
something not fit well? Oh, well, a second set of gloves.
yeah,
Like,
well, yeah, but that's because it was evidence, so he couldn't actually touch it. Because then it's like, oh well, now his DNA really is there.
but the thing is like,
Yeah,
why do you have some, like, the whole
Why
thing
sh-
of fits like a glove is there
Yeah.
for a reason.
yes,
And it's not like fits like a second pair of gloves.
yep. And guys, real quick, 'cause I know Helen might be leaving soon. She was like you guys to join her for her show tomorrow at 4. She does Hearsay for Days. It's 4 Eastern. Well, actually, it's today, so that'll be, like 14 hours. So, hold on.
Well,
Let's-
I appreciate you sharing this one with me, because it's a fascinating case. I hope it holds up.
Yep. Yeah. Well, yeah. Scott Peterson, because she's talking about Scott Peterson, because his case might be coming back too.
No,
He
okay.
accused of murdering his wife way back in the. Yeah, he was before all the trial streaming, so that'd be an interesting one to cover. But yeah, the Delphi stuff is. I'll catch you up on a lot of it, because there's so much garbage.
It seems just like an
And the trial
absolute
is
mess.
set. The trial has been set because in Indiana, you file a motion saying we want our jury trial. The court has to, by the rules, set it within 70 days. So it's already been set. May 13th.
Huh.
So it's yeah.
That one, yeah, I gotta look over that. I see if Delphi defense lawyers get thrown in jail on Monday. Can you do a drinking stream for it?
Yeah, no, I'll definitely be on Monday afternoon once we learn what happens. Because there's a motion to dismiss for Monday, and then there's a motion for the contempt. So we'll see.
It'd be really interesting if they granted both. We're dismissing this and we're throwing them in jail. Someone's going to jail.
If she did that, I think the attorneys would say, fine, we're willing to trade. They would trade their freedom for Richard Allen's, but Judge Gull is not going to do that, sadly.
I did once tell my wife, I was like,
Yeah.
if you come home and I'm not there, I am in a jail cell because I've been held in contempt. Because I was heading off to do something that I knew was going to piss off a judge. And I didn't get held in contempt, but I did get yelled at. My client didn't go to jail, so that was the win.
Mission accomplished. Yeah.
Yep.
So.
And I should note, I didn't do shit wrong. That judge was later
removed.
Not so much removed. At a certain age, they have to get their judgeship renewed every year.
Mm-hmm.
And they refused to renew his judgeship, even though it's normally sort of a formality, on the basis of a list of complaints. So
that way works. That's a way to. If only it happened more. I bet.
Maybe I should cover the case at some point in my.
Well, it's not like you can piss him off and run into him again as a judge.
The guy does own a lot of guns, though.
Well, that's. You think he's not the only guy in Alberta that owns guns that's a lawyer, so that's
yeah.
Don't be you know how much street cred you would have. Because that's where people have threatened me. It's like, you know what, I could live stream that. I'd live stream with a GoPro and just like Christchurch, except it's legal.
It's like, oh, cool.
Yeah.
I occasionally get gun or death threats from anti-gun people,
Yeah.
and
I don't
I'm
think
always
you
like,
understand how that works.
yeah, the one guy's like, hey, I'm coming to your house, and we'll see how well your guns do protecting you. You know, I'm not going to need a gun to kill you. And I was like,
Oh, does he study the
oh,
blade?
safari, dude.
Yeah.
Like,
Did he know where you lived at least?
no, he
Oh,
just said he's coming to my house.
Oh, well, yeah, it's like, okay, cool. See, I don't get any threats. That sucks.
It's the anti-gun folks that
I mean, it's I wish I got threats because I could be like, okay, cool. I'll like if you survive long enough, I'll give you like punch and pie, but you gotta get through.
I'd just be like,
I'm not a
yeah,
farmer.
okay.
Like I know it's not. I have to say no. If he like, I'm not a foamer, and I know when I say that I'm not a foamer, that means I'm a foamer, because only a foamer would get mad and say they're not a foamer. I am not a foamer, guys. I am not a foamer. I don't like trains. Do I need to go derail a train to show you how much I'm not a foamer?
See, a foamer might derail a train just so we could be closer to the train.
Oh, yeah. See, and that's the problem. Yes, and then my community, my sentence will be community service. Like, I have to go work at a train museum, and that's what a foamer would want. So,
I'm just trying to think of how. Yeah, it's just like, no, jail. That's what you'd have to do.
yeah. So, all right, guys. Well, that is it for us tonight. I will see you guys around. We'll see you guys tomorrow morning. Probably around noon. We're gonna get started with the last of the Daniel Howard. Oh, Daniel Howard. He's a cop accused of murdering his wife and staging her suicide. He got caught.
Oh, that's the bathtub.
Yeah, he got. Well, it's in Coeur d'Alene, Idaho, which is across the border from Spokane, Washington. Friday night, he got caught at the Spokane, Washington airport.
Ooh.
Yeah. So the trial's getting delayed probably at least a day. So
I'm just gonna say, that's gonna be. They're gonna bring that up.
That's circumstantial evidence. But the thing is, the state already rested their case, so it's like, how does that? Where are they gonna get to throw that in?
If I was the state, I'd apply to reopen.
Oh well, I think they probably could argue they have the right at rebuttal to say, look, he's an innocent guy. Well, innocent guys don't show up at the airport, so
I'd apply to reopen.
Yeah.
Like, even if the defense just says we call no evidence, we close our case.
Yeah.
I'd apply to reopen and be like,
oh, I think so.
We got new evidence mid-trial.
Yes.
So
but yeah, he's sitting in jail currently. So in Washington,
I don't think they're going to give him another chance to visit the airport.
No, and that's the thing. He's been out on bond since basically since they arrested him. So
did he have a ticket in his pocket?
He was told there was a restriction on him. He couldn't be within 2 miles of an airport. So I'm assuming he had GPS monitoring on. So
now I just wonder, like, was he actually at the airport, or was he driving
it sounds like
by
he was
it?
like at the airport. Like,
oh god,
not like driving by. Although to drive by, that doesn't make any sense because that's like driving across state lines. But you're driving.
You just get guys who get guys who get accused of like crimes against kids, some of whom have done it and some of whom haven't.
Yeah.
But they get restrictions like you can't be within 100 meters of a park.
Yeah.
And sometimes they're like a block over, and they're like, I didn't know there was a park there. Like, the next block over. I don't know.
They're at their buddy's house. Yeah. So.
Yeah. So like that's a different scenario. Mm-hmm. It's like they're sitting there drinking at the bar. A cop rolls up, and it's like, did you know there's a park at the other side of this bar? It's like, no.
Yeah.
Yeah. So.
And Runkle, what time's your Monday show?
Usually run it at 6:30 Mountain, so 8:30 Eastern.
8:30 Eastern, guys. He'll be on then. So, and I'll be on tomorrow at noon. So we'll see you guys. Take care. Bye.
Bye.